I have your lordship leave to mention one matter, lordship. Item number 472 of today's list, lordship. The mother of the petitioner expired. That's why I am moving.
When did she expire?
Lordship, 11th January 25.
Why is there?
I have annexed the copy, lordship, of the death certificate.
Annexed to what? You have filed an application.
Lordship, item number 472. The matter is appearing today's list, but I am mentioning, lordship, for upgradation, because lordship, the mother of the petitioner expired on 11th January. I have annexed the death certificate, lordship.
Why is the death certificate?
Original is with me, lord.
What is the name of your client?
Lordship, Oroj Vishal. Lordship. Husband's name is lordship. Father of the name, father.
Mohammed Vishal.
Shami Nur Mohammed.
Naru Vishal. Father's name is Naru Vishal.
Aroj, what is the father's name of Aroj?
Naru Vishal.
But Nur Mohammed Vishal is the husband of the deceased.
Lordship.
So there is a discrepancy in the name of the father of Aroj Vishal.
To be mentioned tomorrow.
Bring all these particulars.
Lordship.
Mr. Consul.
Inform the State Council, sir.
Lordship.
Find out who is appearing for the state.
My lord, may I permit, my lord, on behalf of Mr. Mukherjee, my lord, he has not been able to come to court today due to some back pain, my lord, from last night. My lord, there are few matters.
Mr. Milord Mukherjee, unwell.
My lord. My lord, there are few matters.
When the matters are called on, indicate.
Lord, on 3 dates, my lord.
Huh?
There are few matters, my lord. If the matters may be divided into 3 dates, my lord. We'll mention at the time of call, my lord.
Yes.
Lordship, grant me leave to file the bail application with the certificate.
Your Lordship, a matter for upgradation.
Why?
The petitioner is suffering from acute kidney disease, Your Lordship. Serve upon the office of the learned public prosecutor.
We mentioned tomorrow.
Lordship, I be permitted to mention item number 988 of today's list on ground of medical emergency because the petitioner who is in custody is at the advanced stage of pregnancy and the date for delivery of a child is fixed for tomorrow. I had mentioned
tomorrow,
my lord.
And you're mentioning today.
Well, it has been mentioned earlier. I have mentioned it, but it has not been upgraded. So
nobody mentioned about delivery, imminent delivery.
The medical emergency was mentioned, madam.
Please, we are not so inconsiderate. To be mentioned tomorrow.
988.
My Lordship, may I allow to mention a matter under the heading inclusion of bail application?
My lord, may I please mention one matter? It is withdrawal. Habeas corpus matter. It is today's list in 1993. My lord, I have to withdraw that matter.
Withdraw?
Yes, my lord.
Habeas corpus. Do you know who is appearing for the state? Doesn't matter really.
My lord.
Tomorrow, my lord, to be mentioned. My lord.
To be mentioned tomorrow.
Yes, my lord. 993. I'm leaking.
Relaxation of condition.
Lordship, may I be permitted to mention two matters?
Just give the slip. Don't mention.
Relaxation of condition.
Whatever it is, give the slip.
My lord, may I permit to mention one matter, my lord? Today's daily list item number 15, my lord. As in this matter, my lord, Mr. Pita Mojumdar is appearing and my client wants to give this brief to Mr. Senior Counsel, Mr. Milan Mukherjee. So as sir is not appearing, sir, can...
Hey, call the list.
Lordship, item number 1, I'm praying for not pressing this application.
Not pressed.
Grateful, Lordship.
I am for the petition eminent. Your Lordship was pleased to call for a report as to the progress of the trial because this petitioner before your Lordship is in custody for 6 years.
This is the report, Lordship.
Madam, tell us what is the cause?
There are several causes, Lordship. Who accused Mono Singh was absconding for long time, and then subsequently PP was ill, and production was not kindly see the small report, Lordship. This is very unfortunate state, Lordship.
What is the stage?
Only PW1.
So you are opposing or no objection you are giving? You are giving no objection.
Defense counsel also take time, Lordship.
How many witnesses you have examined so far?
There are so many witnesses.
How many have you examined till date?
Lordship, I have asked the police station. They did not tell. In this initial state, Lordship, they cannot tell how many witnesses.
Initial stage of what? Initial 6 years.
কটা witness examined হয়েছে সেটা মহা মুশকিল। That is what we were asking.
That is already written, Lord. Only
many,
PW1.
how many witnesses are there in the
বলতে
charge
পারবে
sheet?
38 জিজ্ঞেস করছি যে কটা করবে তোমরা বলতে পারবে পরে দিয়ে দিতে হবে
হ্যাঁ।
এসো
But he is a resident of Bihar.
My lord, all the accused persons are resident of Bihar. Other persons are also resident of Bihar.
they are on bail.
They are on bail, my lord. They are on bail.
Lordship, TI parade was run and both the victim identified this man.
In respect of the other accused, the similar evidence is there.
Why you have failed to convict him? Give me the reason.
Lordship, the other same footings, Lordship, they got bail. I have nothing to say.
My lord, I am renewing my prayer. I am
You
renewing
have
my
to
prayer.
stay in the
My lord,
local jurisdiction of the court.
Mal-
Where
The petitioner renews his prayer for bail, which was last rejected on
my lord, it was last rejected on June 2022. My lord, I am saying
in June, 2022. Stop.
no, my lord, it was in July 2023, page 26, my lord.
ঠিক আছে? July 23. Stop. He says that he is in custody for about 6 years. Stop. Only 1 out of 38 charge sheet named witnesses has been examined. Stop. On the touchstone of Article 21 of the Constitution of India, comma, he renews his prayer for bail. Paragraph.
when you have been arrested?
My lord, I have been arrested on 13th of February 2019.
13th of February 2019.
Right, so,
Almost.
Status report filed by the state be kept with the records. Stop. The report is completely useless. Stop. It does not mention how many witnesses the prosecution proposes to examine. Stop. Therefore, comma, we take it, comma, that all 38 charge sheet named witnesses are intended to be examined. Stop. Hence, comma, we see no likelihood of an early conclusion of the trial. Stop. The petitioner is in custody for a very long period of time. Paragraph. Without touching the merits of the case and solely to prevent infringement of the petitioner's fundamental right to personal liberty and speedy trial as enshrined in Article 21 of the Constitution of India, comma, we are constrained to allow the petitioner's prayer for bail.
He shall remain within the jurisdiction of Girish Park Police Station and shall meet the IC Girish Park once in every week.
My lord, I shall meet the IC once in every. My lord, if subject to correction by your lordship, my lord, instead of Girish Park, if I remain within the district of Kolkata, my lord.
Why?
My lord, Girish Park is a area which is, my lord, getting a room rent and everything. I'm not a resident of here, my lord. If some relaxation, I'll meet the
You should have remembered that when you committed 364A.
my lord, I will.
বুঝতে পারছি। Item number 3.
The report was called for. They have stated that the petitioner's father is not well.
Here for the petitioner.
They have prayed for upgradation on the ground that petitioner's father is not well. This is the report.
He is 86 years old. He is suffering from pneumonia. Pneumonia and my lord, he has been advised immediate hospitalization. That is the cause.
There's nobody else at home.
This petitioner's wife is there. No?
His wife is there.
So how long you are in custody? How long you are in custody?
My lord, 106 days. Yes.
106 days. And
Deportation of over 3 crore
Alright.
rupees.
and
No, no, I,
Deportation of 3 crore rupees.
Alright.
Over 3 crores.
my lord, I am
Sir,
telling
this
you.
is the volume of the
Lord.
case.
Kindly hear me for just 2 minutes. But this petitioner,
Yes,
an
you've recovered the money. Yes, trace the money.
Oh, my lord.
Anyway, you will, now that you have him in your clutches.
so after hospitalization, you will come back to custody.
my lord,
Get bail.
my lord, there is none
After-
else.
No. What we are saying, we can give you interim bail, arrange for your father's hospitalization, and then come back to.
Ready? Ready?
Are you following what my brother is saying? What? Tell us, what is he saying?
No, my lord, if there is no,
We cannot
Indian
we cannot give you confirmed bail. Is it clear? Is it cough, pneumonia, cold and cough?
no, not only cough, my lord, he is 86 years old, pneumonia, and he has been advised immediate hospitalization.
What do you want? Confirm bail.
My lord, if your lordship considers that,
No. It cannot be a ground for.
then my lord, kindly give us some time, my lord, 10 days or 15 days, I will come back,
Yes.
and then lordships will.
We
my
will
lord,
consider on merits.
Fine.
Then we will consider on
Fine.
merit. Issue. Report filed by the state be kept with the records. Acha, आगे बोलो. Read order dated January 10, 2025. Stop. Report filed by the state be kept with the records. Paragraph. It appears from the report that indeed the petitioner's father is unwell and requires hospitalization.
My report does not say so.
He so. Not even unwell.
My lord, it's only stated that cough and cold, and he is in strongly conscious condition. It has not stated that he needs hospitalization or anything else.
My lord, is it by the
Report is very specific.
কি বললো? Indeed is unwell. Stop. Considering that the petitioner's father is 86 years old
22.
and may require urgent medical attention, comma, taking a lenient view and on humanitarian grounds, comma, we are inclined to grant interim bail. বলার ব্যাপার নেই।
It is BP 140/80. If the person's having BP at the age of 85, 148, that means normal.
140 by
More than
80.
normal.
140 by 80.
Normal.
That is the blood pressure.
Yes.
But kindly see the prescription, my lord, what has been stated.
What has been
This
said?
is,
Tell me.
he is in an acute condition.
Which page? Which page?
My lord, the
My lord, this prescription, he is referring to the prescription, which says,
kindly look at the
feverish
prescription.
Pacho.
The other day I had handed up.
my lord, it says feverish cough and cold.
দিও না তাহলে, দিও না।
We are not happy with
My
it.
lord, blood pressure, my lord, does not depend upon pneumonia.
Maybe.
Where does it say pneumonia?
My lord, let them say whether the investigating officer has,
Already 12 দিন হয়ে গেছে।
my lord, let them say whether the investigating officer has consulted the doctor. Doctor will not say.
Let the doctor swear.
For 7 days, we are granting 7 days interim bail.
My lord, kindly make it 10 days.
10 days.
10 days.
That he needs to submit a report.
for
whether
10
he's
days.
admitted or not. His father.
For
was
10
admitted or
days from his date of release. Accordingly করে দাও। করে তারপরে this order of interim bail shall remain operative. আজকে কত তারিখ? Till January 29, 2025, or until further order, whichever is earlier. List the matter on January 27.
He shall surrender. He has to surrender. The interim confirm হচ্ছে না. On 29th, he shall surrender. Now, before 29th or on or before 29th January, the petitioner shall surrender before the concerned trial court,
Learned trial court, learned trial court.
and he shall be taken into custody and remanded to JC by the
On 29th, Lordship may hear it out on merit.
Why?
We will see, sir. You can't have everything. তাহলে কবে লিস্ট করবো?
30 আরেকটু পরে করে দাও।
তাহলে লিস্ট করো।
না 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 না, এটা ওটা ইন্টারিম বেল, এটা কনফার্মেশনের কোনো ব্যাপার নেই। জাস্ট ওনাকে হসপিটালাইজেশনের জন্য দেওয়া হচ্ছে।
31 তারিখে প্লেস করো। 29 অব্দি আছে। হ্যাঁ, 29-এর ভেতর সারেন্ডার করবে।
31st.
Bail for limited purpose.
27th, 31st, no? 31st.
তাহলে শোনো, ইন্টারিম বেল ফর 10 ডেজটা কেটে দাও। 10 ডেজটা কেটে দাও, তাহলে ঠিক আছে।
Till 29.
ইন্টারিম বেল জাস্ট বলে।
Till 29.
না।
29 দিতে হবে, ওকে এ করতে হবে, 29 বলতে হবে।
Shall remain operative till 29 বলা আছে। তারপরে উনি যেটা বললেন, stop this order of লাস্টে গিয়ে this order of interim bail, হ্যাঁ, তারপরে on or before 29
On or before. হ্যাঁ,
লিস্ট হবে 30।
But, on the last occasion, I have told your lordship that this petitioner is in custody from 1st of June 2024. There are 36 witnesses to be examined. And your lordship wanted to know what is the participatory participatory role of the petition.
You are in custody for?
Not about 7 months from 1st of June 2024. 36 witnesses to be examined.
that's it submitted.
It has not been committed to the court of session. yet.
Not.
Submitted.
Yes. Trial has not started.
আগের দিন তো ওরা তাই বললো রোলটার জন্য
Trial has not started. It has been committed to the court of session.
So are you not ready?
The Basit Sheikh has fired this out.
Nasimuddin Monto. Nasimuddin Monto.
But he fired the shot, came to the court being armed with firearm. While cleaning away, he fired shots
In the air.
the village. So that was different. One had
The charge sheet doesn't mention Arms Act.
Yes.
there is a prayer for sanction is required for the DS. There is a prayer for filing of supplementary charge sheet.
And there is a counter case. In the counter case, not all the accused persons are on bail.
Nasim Mondal was there.
Yes. Another 164, your lordship will get on page 76.
আসেন শেখ বন্দুকের নলটা আবজুর শেখের মাথায় ঠেকিয়ে বাকি শেখ আর কাসেম মাথা ফাটিয়ে দেন। তারপর বন্দুকগুলো হাতের উপর ঠেকিয়ে নাচতে নাচতে আমি দুটো দিকে চলে যায় নাসিম মন্ডলের বাড়িতে। নাসিম মন্ডল ছিল, ওদের সঙ্গে এসেছিল।
But Nasim didn't shoot.
No, but he was also armed with fire.
That's all right. It was not his.
The next flag mark, page 76.
Firearms were issued by Bashir and Qasim Sheikh.
Used by, yes. It is correct.
You
He did not fire the.
Other accused persons were granted bail.
No.
Nobody is on.
Nobody is on.
So we are wait for bail.
Mr. Roy, there is no 120B, no 34, nothing.
It will be done by the judge. Knows the pitiable condition of the police.
যদি ভুল করে আয়ও যদি ভুল করে what can be done?
It will be done by the Those amendments will be done by the learned trial judge.
7
Charge
months.
has been-
No,
No,
it has been committed.
Charge has been
committed.
Committed and transferred to the court.
We are not inclined. You are allowing the,
But there is no participatory role of the petitioner. Allegation was he is one of the members of the.
he was one of the member of the.
That allegation is there.
one of them.
But then there is
the murder. They are সবাই চলে গেল নাচতে নাচতে চলে গেল।
Arrested ব্যাপারটা বলুন, before the FIR was registered, he was taken into.
So we are not inclined right now.
Before the FIR was registered, he was taken
was
into
taken-
custody.
Fast forwarding.
He was see the first forwarding report. Was taken into custody on 1st of June. The FIR is on 2nd of June.
After framing of charge, we may consider.
No, 1st of June he was there.
The learned counsel for the petitioner
Okay.
has submitted that the petitioner is in custody for about 7 months. Stop. Though he was in the alleged unlawful assembly, but he did not shoot the victim at the relevant point of time. The statement of the witnesses recorded under section 164 CRPC only show that he was in the alleged unlawful assembly at the time of occurrence. Stop. Considering his period of detention and further considering the fact that investigation is complete, he may be enlarged on bail on any condition. Stop. Para. The learned counsel for the state, learned counsel, the learned public prosecutor has raised payment objection. According to him, there are sufficient evidence against the petitioner. Stop. The learned trial court is going to frame the charge against the petitioner along with others within a very short span of time. Stop.
The petitioner had an active role to play in the premeditated plan to commit murder of the victim.
We have considered the materials on record. We find sufficient incriminating materials against the so, as the prosecution of the instant case is not suffered from any cause of delay. We are not inclined to allow the prayer for bail of the petitioner. Therefore, bail is cancelled.
কি হ্যাঁ না না খাবে
My lord, I am for the de facto complaint.
Well, like item 5, I'm praying for short Passover Matter. Item 5 and 6.
Not today, my lord, not today. My lord, but
Look, 5, your lordship makes it not to. 6, perhaps is not maintained. I am told by the.
my lord, your lordship would recall on the last date, my lord, I'd taken a point that if it's an SC/ST Act case, then an appeal would lie before the Honorable High Court, my lord, 14A point, which your lordship had kept open, my lord, the maintainability of these applications. So, my lord, one of them turns out to be an SC/ST person, my lord, himself, and the other one is not. Yes, my lord.
So, what is outside?
My lord,
Well, item 5 and 6, I'm praying for short Passover, my lord. Mr. Molik appearing will be matter, she is engaged in court number 28, my lord.
Take this on record and make it not today.
My lord.
So both of them belongs to SC/ST. Only 6. Only 6.
There are 25 other accused persons also, my lord. Actor.
It is not maintained.
So who is here also for sick?
Fine.
Report filed by the state in terms of our order dated January 3, 2025 be taken on record. Paragraph, on the prayer made on behalf of the petitioner, let this matter stand adjourned for the day.
But they have taken a pleading, I think, in item number 6 that they are from the SCST. My lord, I'll make my submissions.
Hey, Devajit.
Item 7. Lord, I am for the petitioner. Lord, interim bail was granted. Co-accused on same footing has been granted bail by your lordships, my lord. I was praying for confirmation, my lord.
Your lordship, filing.
Report, comprehensive report filed by CBI be kept with the records. Stop. It does not appear from the report that there is
Have you read the report?
I read, I have to talk. Yeah, I was.
So you please take your report. Prayer.
Yes,
Please read.
Please read it aloud for everybody to hear.
The petitioner has filed the condition particularly obligation to party in the local area.
They cannot concede, my lord.
Thereafter, I asked from the investigating
I have done it.
the local address has been given, page 9.
Then why this report?
I said we shall keep it here, then we shall confirm.
This report bears today's date. So this is the latest status. And you say bail should be cancelled. Why? Because local address has not been furnished.
It has been furnished, it's there.
Mr. Chatterjee, that may be the fact.
Lord.
You also have gone through, but you did not assist me.
They don't give us, my lord. Unless your lordship say, my lord, they don't give.
Please file a fresh report. Don't file this kind of a report, which does not portray the actual factual.
I have come to, I have just asked you.
But the IO is
Sir, we cannot keep this on record and then confirm the bail. Not today, only.
Obliged.
You have interim bail till
31st of January.
Yes.
Till end of.
Report फिर दी दो.
Obliged. Obliged. Obliged.
They are not reading.
Item number 8.
I'm preparing for the state.
The last
Passover Matter had directed us to file a report with regard to the status of the trial and my lord, when the prosecution witnesses, how many are to be examined. Now, my lord, my learned friend had raised one more question that the PO was on leave. So, my lord, I have taken instruction, PO is on leave. But my lord, out of 18, 3 witnesses are yet to be examined. 15 has already been examined.
How many is in custody?
Now, my lord,
7 years.
he is in custody for 7 years, but the petitioner number 3 and 4 has been absconding for 3 years. So, my lord, there was a delay in trial. Now, my lord, there is a court which has taken in charge of this, my lord, these cases with my lord so direct, since only 3 witnesses are left. My lord, that court may carry on with the remaining 3 witnesses. So, my lord, then we will be able to finish it up with the remaining 3-4 months, because my lord, there is a direction of this court. My lord, can you see page 15 that within 1 year, after, my lord, because this is the 5th time they have come up. Earlier, 5 times, my lord, he's present.
Yes, you have precisely 2.5 months.
No, my lord, from the next date of hearing.
Which, yes. Next date of recording evidence.
My lord. So it was, even if we consider the date of, my lord, the passing of this order, so my lord,
2.5 months. That's what I'm saying.
April.
30th April.
Yes, my lord. So my lord, my lord, if we consider the next date of hearing, another 1 or 2 months. So my lord, I would just request your lordship that my lord may allow us to examine the remaining 3
Eyewitness.
My lord, they are all the formal witnesses. The police.
Do you have an eyewitness
Yes, my
to
lord,
the
there are
incident?
3 eyewitnesses. My lord, can you consider the 164s of the 3
No,
eyewitnesses?
no, 164 deposition.
My lord, depositions copy we don't have. If they have, my lord, they can, because
You have copy.
Today, my lord, I have not brought because I was on the impression because my lord, the 10 witnesses they have exhausted. 8 were examined and 2 died. And my lord, the next.
Roy, they are saying they will examine 3 more witnesses.
My lord, the court is vacant since October. This court is lying vacant. And in April is the next probable date. But on that date, the court will be filled up. There is no such assurance. My lord, since your lordship is dealing with Article 21, my lord, in all the cases, in
So what are the deposition against you? They are exonerated you. So as that.
my lord, not so far as my instruction, but today I have not. But my instruction is this: there are evidences by the some of the witnesses, not that they have all exonerated us. But I must be candid before your lordship. But
My lord, it's a mandatory life imprisonment, my lord.
Bring the.
But my lord, the fact remains I am in custody for 7 years. More than
One of the exceptional cases, we will say so in the order. We will say so if necessary. We want to have a look at the depositions.
Some of you been absconded for 3 years.
my lord,
3 years, my lord.
my lord,
We've got records.
but absconsion, my lord, at this stage, after 3.5 years, they are in custody.
Abhijit.
More than 4 years, they are 7 months, they are in custody.
So why you have diluted the proceeding? For first 3 years, you have diluted the
My lord,
proceeding.
my lord,
Then you are claiming.
my lord, your lordship,
We can always distinguish we have the ability to distinguish cases, okay?
my lord, in 17 is the occurrence.
Last 3 years you have absconded.
20, my lord, he surrendered. My lord, 2 remaining.
That is enough for the day. Enough for the day. We would like to have a look at the
Petitioner will be
depositions of the witnesses already examined. Stop. We are conscious that the petitioners are in custody for over 7 years. Stop. The state says that only 3 more witnesses will be examined. Stop. There are eyewitnesses to the incident of murder.
Who implicated them?
Who have implicated these petitioners. Stop. Paragraph. While it is true that ordinarily the fundamental right of an accused to receive speedy trial and his right to personal liberty overrides all other considerations, comma, the same is not a rule without exception. Stop. If we find that the alleged offense is grave in nature, comma, committed in a gruesome manner, comma, there is clear evidence implicating an accused person, and the minimum mandatory punishment is life imprisonment, comma, then in all cases, comma, the accused person cannot claim recourse to Article 21 of the Constitution of India. Stop. There must be a balancing act. Stop. We also notice that 3 accused persons, 3, no? No.
My lord, 3. Out of 18, 3 are only left to be examined.
How many
Who are
absconded?
before your lordship?
Absconded. Who absconded?
For absconding petition number
2 accused persons absconded for about 3 years, which contributed to the delay in progress of trial. Paragraph, let depositions of the witnesses already examined be produced before us by learned advocates for the parties on the next date. When do you want it, Mr. Roy?
The next week I will try, but the fact remains, my learned friend submitted before your lordship, 15 witnesses have been examined. But let them stick on that point.
We have recorded here that 3 more will be examined.
Your lordship kindly record that 15 witnesses have been examined.
Three more একটা জায়গায় লেখা আছে যে
15 witnesses they have examined.
3 more witnesses will be examined. আগে একটা জায়গায় কোথাও আছে। ওখানটা ওটা add করে দিও। Learned state advocate says that 15 witnesses have been examined and only 3 more witnesses will be examined. ঠিক আছে? When should we?
Sufficient. I will show to your lordship the
report will be kept with the record.
Falsity.
Yes, when?
Next week.
Absconsion is also false.
22nd.
That is not. The absconsion is a right.
Right. Absconsion is the right.
Because your lordship will find, but in my experience, the police do not make any attempt. But if your lordship consider the case diary, your lordship will find police made a minimum attempt to trace him out. If he was absconded, what steps they have taken for proclamation and attachment? Let them show.
Well, is this the stage of saying all these things?
No, not stage. My lord,
yes.
My lord asked me that. That's why.
Next.
My lord, in this matter, I'm appearing on behalf of the appellant, my lord. My lord, in this matter, I'm appearing on behalf of the appellant. My lord, I'm in the custody. This is my matter. Let me submit, please. My lord.
Mr. Roy, you have not.
My lord, may I?
The copy.
My lord, may I humbly submit, my lord?
Under the SC Act, which has to be now admitted, and then after that, let my learned friends serve me a copy of.
My lord, victim may not be needed to be the party in this matter, my lord.
Sorry?
This is a bail matter. I'm learning from.
Victim is not necessary party.
My lord, victim. This is a bail matter, my lord.
So, at every stage.
I will be serving, my lord. My lord, kindly keep this matter. Today I don't have. Kindly keep this matter on next week, my lord.
Next date টা কবে হবে? না এই তো সামনেই 17th.
My lord, 17th.
Only one. Today is the date fixed for evidence. 14, 15, 16, 17, and 20. These are the dates for the evidence. That they have filed this to Scotland.
No, my lord. This is a blame game.
You will clarify.
This is a blame game going on, my lord.
Clarify that.
My lord, there are lacunas. My lord, the tainted motive of the prosecution is portrayed over here, my lord.
Monitored investigation.
How long are you in custody?
My lord, more than 570 days.
Very good. Be there. Hey, issue.
My lord, kindly. My lord,
this is an appeal against the provisions of. This is an appeal under the provisions of the SC/ST Purota Diye Debe Act against an order refusing bail to the appellant. Let service be effected on learned advocate for the de facto complainant. Stop. Paragraph. List this matter once again on.
My lord, 29th, my lord.
State must be a party.
No, state is a party. I have served upon the state. Okay. In the list.
Be appearing, then they will give you a copy.
My lord, I have already served upon them.
Sir, why make things complicated? You have dirt of copies.
I will serve.
Give another copy.
I will serve, my lord.
কি বললাম? 22nd.
My lord, 29th, my lord, kindly.
29th?
My lord.
29th ki date? 28th.
My lord, 29, 28, I have personal problem, my lord. 29, after 28.
Then after 29th, not 20.
After 29.
31st.
31st, my lord.
31st.
Highly grateful.
Paragraph, we clarify that pendency of this bail application will in no way stand in the way of the learned trial court proceeding with the trial.
My lord, one line may be added, my lord. I have not served upon with the proper copy of supplementary charge sheet, my lord. I have reflected in my statement body also of the petition.
Tell the learned trial court.
My lord, if it may be added, I will be.
Can we direct?
No, I'm just.
On 31st, then.
My lord.
Next.
Highly grateful.
Cholo, taratari cholo.
Item number 10, my lord. My apologies, first apologies, because I have made the state a party, but I should have. The investigation was, my lord, handed over to the CBI later on.
Add them.
And come back with a
Well, this is our report in 2021 itself. It was handed over to the CBI. And my lord, by an order passed by the Honorable Apex Court, there has been stay of all further proceedings.
देखो, report filed by the state in terms of our order dated January 3, 2025, be retained with the records. Stop. We find that investigation of the case was handed over to the Central Bureau of Investigation, bracket CBI, pursuant to an order of this court. Stop. Therefore, let CBI be added as a party respondent and service be effected on CBI. Stop. Affidavit of service be filed in court on the next date. Paragraph. Plus, that is it for the time.
Serve it upon the.
May the state be allowed to recuse from.
Yes, why? What state's presence is not necessary. Paragraph let the name of the state be struck out from the cause title of the.
May I pray for one more thing?
Bail petition, as the state's presence is not necessary for deciding this bail petition.
Since, my lord, there was a direction on the last occasion on the status of the trial, my lord, that direction be given on the
paragraph. And let them appear.
Your mistake, and you are trying to.
How long are you in custody?
More than 3 years, 5 months.
Acha, sir, কবে রাখছো ম্যাটারটা? When? Either 17th or 22nd.
17th, but I'll serve it today in the office of the learned ASG. But let there be a direction to serve it upon the office of the ASG. My lord, ASG will, my lord.
That we don't know. Why? Serve on ASG, serve on CBI also.
As you lordship.
17th.
Liberty to correct the cost.
Leave is granted to the learned advocate for the petitioner to make appropriate correction in the cause title of the bail petition. Strike out state's name, add CBI.
My lord, please, your lordships. My lord, it is that matter where a person was, his actual name was, as I claim, his name was Gaur Rai. He was shown arrested as Gaurango Shil, a Bangladeshi. Yes, I will be showing. He was produced as Gaurango Shil. Thereafter, I had prayed before your lordships that he was having valid voter card, and your lordships directed for biometric authentication as to whether these two persons, whether this Gaurango Shil, he is the person, his last date, your lordships wanted to know me whether there is any Indian, my lord. Yes, my lord. My lord, what is? My lord, may I just be very frank to your lordship? My lord, it appears that excepting ration card, Aadhaar card and voter card, he has got no other Indian credentials, my lord. That is, I may be very frank with your lordships. My lord, he is around 42 years of age, and his son and wife.
Educational qualification. He, according to you, he took birth in Indian territory.
My lord,
Which school he studied?
my lord, may I just be very candid with your lordships? My lord, my point was that this person was having Indian documents. Regarding his birth in India, perhaps I have not, subject to your lordship's correction, I have not stated that. I stated that he is possessing ration card and valid voter card and Aadhaar card.
There is a question whether you are Bangladeshi or Indian.
My lord,
you are
so
saying
far,
that you are Indian.
no,
You are
yes, my lord. Only basing myself, my lord.
Please,
my
there
lord.
is an allegation that there is a fraudulent Aadhaar card or something like that. So I want to know, to help you.
My lord, I understand, my lord. My lord.
His educational qualification, what is the.
My lord, I took instruction, my lord. As it fell, my lord, as it fell from your lordship, I asked, my lord, he is unable to produce any more, my lord, other than these 3 documents, my lord, upon instruction, my lord.
Learned Council has submitted that the petitioner is an Indian citizen. The allegation that the Aadhaar card is a fabricated one is not correct. Stop. Considering his period of detention, he may be enlarged on bail. Stop. Para. The learned counsel for the state raises strong objection. According to him, he is a Bangladeshi national. He produced fraudulent Aadhaar card.
Yes.
And
He obtained that
he
card.
obtained fraudulent and fabricated Aadhaar card. He is not an Indian national. If he is enlarged on bail, the prosecution may suffer. Para. As per our direction, the learned counsel for the petitioner has failed to produce sufficient documentary evidence showing that the petitioner is an Indian national. He has failed to submit the any educational certificate showing that he studied in any of the schools in India. Further, birth certificate you have produced.
No, my lord.
No birth certificate has been produced from the side of the petitioner showing that he took birth. He was born in the Indian territory. Stop. Considering the entire materials on record and also taking into consideration that fraudulent and fabricated Aadhaar card has been produced, we are not inclined to allow the prayer for bail of the petitioner at this stage.
My lord, only
Prayer stands rejected.
my lord, only one thing, my lord. Only one thing. My lord, he may be given the liberty to rely upon any document at the time of trial. I'm not
You have
because my lord, the Aadhaar card is apparently existing.
একটা জায়গায় যেখানে
I'm grateful.
যেখানে স্টেট কাউন্সিল বলো তো বলো অ্যাকর্ডিং টু হিম, তারপরে হি বলো না, তার মানে হি মানে নিজে হয়ে যাচ্ছে দি পিটিশনার, ঠিক আছে? যে আরেকটা লাইন অ্যাড করে দেবে আমাদের যেখানে অপারেটিভ পোর্শন যেটা কোর্ট দিচ্ছে, all the documents produced and relied upon by the petitioner are highly suspect in nature. And lastly গিয়ে dismiss করার পর we clarify that all observations made in this order are only for the purpose of disposing of this bail application and shall have no bearing on the trial.
Item number 12. My lord, I am for the petitioner. My lord, may I start with the weakest point which I have got, that is your lordship's order in respect of one of the co-accused.
This is a report that was directed to be filed.
Lordship, kindly come to the order dated 6/12/2024, by virtue of which your lordship was pleased to reject the prayer for the bail of one of the co-accused called Gora Khan. And while doing so, your lordship had also observed
612 এর order কই? 612 আমি তো আছে।
Lordship, I have got a copy. Lordship, may I hand over a copy?
Just 1 minute. কোথায়?
It was in respect of another.
6 and 7 fixed as next schedule. আমরা রেকর্ড করেছিলাম. What happened on the 6th and 7th of
Yes.
January? Examination?
Nothing.
Nothing.
No, even the witnesses were not summoned. Kindly.
No, my lord, the learned
were not
public
summoned by the
prosecutor
prosecutor.
was unwell, my lord. As a result, that it could not be recorded.
Even they were not summoned also.
Who was in?
The learned public prosecutor was unwell, my lord. He could not attend the court.
How long you in custody?
Lordship, now this person is concerned 1 year 8 months as on today.
62 witnesses.
There were 62 witnesses. In that case, state has said that they are proposing to examine another 9 witnesses. Already they were saying that 25 witnesses have been examined.
What does the rejection order say that
Yes,
co-accused?
my lord, kindly come. May I hand over a copy of this rejection order?
Copy.
This is the copy. This is the last rejection order in respect of the co-accused. Because that also says the earlier schedule, the witnesses were not examined. In my instruction, they have not been summoned by the prosecution.
No, that is wrong. It is not true.
Your lordship also held that this cannot be said to be a case where the trial can be called as stagnant. But lordship, after that lordship, there is no private witnesses left. All public witnesses, Caesar witnesses, official witnesses. That scope is less now. And so far material is on record, lordship. This Taraknath is differently situated from Goda.
Well, this is the evidence, copy of the evidence, my lord, against this particular person, petitioner. The evidence of the son of the deceased.
কপি তো তোর কাছেই হবে কি দেখা যাচ্ছে এটা বলুন না কিছুই বলা নেই। ভুলে গেছি। So far this person is concerned, he is the owner of a jewelry shop of that area, and he was the regular visitor and he knows the de facto complaint.
He tried his best to mislead the complainant.
What misled? He has lodged the
Yes,
FIR.
yes. That is clearing from the deposition itself.
না না সেটা কি ছিল witness ছিল he was an impressed witness also who extended all aid to.
Yes, and he was a family friend.
He was not an eyewitness.
No.
No, my lord, he was not an eyewitness.
No eyewitness.
That's right.
This is the son. This is the son of the deceased. My lord, the son of the deceased, when he was called from Nolati, when he reached Nolati, thereafter, my lord, he was this particular petitioner, this accused person. He tried his best to convince him that the death was normal, and so that he shouldn't have lodged any complaint. So that he tried to ensure that he doesn't lodge any complaint.
How she died? How he died? What is the cause of death?
My lord, we get PM report. PM report.
Or stab injury, strangulation. What is that?
Strangulation.
Manual strangulation.
Yes.
And lordship, so far Goda is concerned, they based their case on the fact that there was the fingerprints matched.
This is your first application.
This is my second
application.
Where is your earlier rejection?
Yes, ma'am. This is the earlier rejection. Right.
This is a postmortem report.
So far, the timing of the incident is concerned now, lordship. This was done.
Uttarakhand and others, my lord, were brought from other state.
Lordship, kindly also
And
consider.
this is the person who had done that.
This is the last scene together.
Yes.
No, what?
He was last seen together, my lord, as per the CCTV footage.
What? No, last seen together. Not. It cannot.
That is what
last seen together.
Lord, that is the reason, my lord. And there are call detail records also. The CDR details are also there, my lord, and as well as there was one footage only which could be seen when they were exiting.
Mr. Chatterjee, the major problem is that you have suffered a rejection on merits. Now, where is the change of circumstance?
No.
Apart from you can argue delay.
Yes. But well, the change of circumstance is that when my prayer was rejected earlier, after that, a substantial witnesses have been examined. And depositions have come before the court. And lordship, the state, I don't know what state has relied on that, apart from what has fallen from my learned friend, that this person was trying to mislead the de facto complainant. Apart from that, is there anything else against this person?
Yes, my lord, kindly see
And
my lord,
the
report,
incident,
page 2.
You have to then consider the deposition. All depositions are available here.
My lord, not with me, my lord. I could obtain only this one, my lord. If my learned friend has a certified copy, my lord, he can produce. The next schedule is that there is a 3-day schedule in February. My lord, in the report it's mentioned 10th February, 11th February, 12th February.
Unless the deposition of 24 is PW 24 is not complete, no other.
No, this deposition is kept for further cross-examination. And my lord, this witness whose deposition is still left, that is HON'BLE, Sukhdev Das and HON'BLE, these are the two prime witnesses.
When they will call?
Two prime witnesses you have kept for the end.
No, my lord, this Sukhdev Das has already been recorded. HON'BLE is going to be recorded, my lord. That is in progress.
What witness?
That is his evidence is in progress. My lord, next date is fixed on 10th February, 11th February, and 12th February.
How many more witnesses do you examine?
9, my lord.
1 month prior it was 9, today is also 9.
Yes, because it
so there was no progress.
3 months.
Before 3 months also this was 9.
The month of October.
Darao.
Come back after the IUTS is complete.
Shall we record?
They are
Yes,
not
yes,
completing that.
in the report it is mentioned.
Lordship, there is no eyewitness in this case.
That's all right. There is CCTV footage you were
Now,
seen.
so far the CCTV footage is concerned, now Lordship kindly consider. That's why I was trying to indicate one thing. The CCTV footage, when the examination, the forensic examination of the footage came, there is a complete discrepancy regarding the timing.
Mr. Chatterjee,
It says
that the
9.
trial court will consider.
Now, Lordship, these are the things, Lordship, which makes the case completely weak. Now, so far the observation of your Lordship 1 month back regarding the stagnating
Cases of
days of
2023,
trial
April
is concerned.
2023.
Saying that there are 2 eyewitnesses. One of
There was
That
no
is as
eyewitness.
per
There
the
was no
report
eyewitness.
which I have received, my lord, there are 2 prime witnesses. That is
Lord,
Sukhdev Das and
eyewitness,
HON'BLE.
no eyewitness.
My lord, that is what I have stated here.
Lordship,
My
they
lord,
are
can you see
official
the page 5, paragraph 5 of the report that has been given, my lord?
Lordship,
Page 2, my lord, paragraph
kindly
5.
consider one thing.
what
This
is
person.
the case against him? What is the evidence against him right now?
My lord, the evidence that I have handed over to your lordship.
He's misguiding.
Look, that is it, because he had contacted these 3 3 persons.
Apart from this,
Nothing.
no evidence against him.
But he is the main perpetrator of the crime.
Only misguide. So, tell the evidence is
Well, that will be evident only after the CDR is proved.
idiot.
After the call detail records are produced before the trial court and
everybody will
well, then in that case, well,
There is any evidence showing that they are last seen together.
No, nothing.
How him, please.
my lord, he was seen together along with the above noted co-accused persons when they entered into the 2nd floor of Mongoldeep Lodge at the time of offense on 23/4/2023 night, when the deceased Dr. Madanlal Chaudhary lived alone, and the very next day his dead body was found. The witnesses who had seen him coming out.
Dead body was in the platform or in
No, in his house.
And it was locked.
He used to live alone.
Oh,
And that same building was let out to live. In the ground floor, there are several other shops.
there are certain evidences showing that you are last seen together.
There are evidences, my lord.
The position, if it is Lordship, the thing is that I don't know on the basis of what they're saying. There was no I will show from the deposition. If your Lordship take up the depositions, then it would be an apt case for granting bail that I can demonstrate.
Oh, no, Mr. Chatterjee.
Lordship, the question is.
Sorry, no, we have heard you enough.
No, Lordship, the only thing is kindly consider, Lordship, apart from, because this is also a ground to seek the bail, that is what is the evidence, quality of evidence.
We'll post it after the next schedule then.
Lordship,
Come back, let us see.
Then if, and kindly direct them to complete the schedule.
That is obvious.
When
They
is the
have
next
to complete.
schedule? When?
My lord, 12th February is the last date. 10th, 11th, and 12th February
Cross-examination.
for cross-examination.
The petitioner renews his prayer for bail, which was earlier rejected on merits by a coordinate bench on April 30, 2024. Stop. The petitioner says that the witnesses so far examined by the prosecution do not implicate him. Stop. Paragraph. We have seen some of the materials on record. Stop. It can't be said that there is no incriminating material against the petitioner. Stop. We are told that in a paragraph, February 10, 11 and 12, 2025, is the next schedule fixed for examination of witnesses. Stop. Paragraph. List this matter once again on February 14, 2025. Stop. The latest status report should be filed before us by the state on that date. Stop. It is expected that the remaining witnesses, the examination of the remaining witnesses will be completed.
Scheduled witnesses maybe because
The
scheduled witnesses
of the scheduled witnesses will be completed during the next schedule fixed by the learned trial court. Paragraph, the list to bole diyechi. Let this order be communicated by the parties to the learned trial court. Grateful, madam.
Fingerprint expert was there.
Yes.
Matches.
No, for with Taroknath, no match.
Status
Buddha,
report
there
filed
was an
by
observation.
the state.
Commit the he had engaged 3 persons to commit the crime, and those are all from outside states.
87 years old. The deceased.
Unfortunately, nobody has been. He was a doctor, or nobody is being tried. A very popular person out there, and owner of that entire building. There was
What is the motive?
But there are several disputes regarding that property and all these things. Land disputes were there.
Happened. Lordship, normally the PW1 is the de facto complainant, but in this case, PW1 produced by them.
You can
is
already
the
say this.
doctor, postmortem doctor. Court.
That
shows that something.
Your Lordship, I'm led by Mr. Mukherjee and I'm praying for not today.
Chalo.
My lord, 15, I am appearing for the petitioner. My lord, in this matter, Mr. Pritam Mojumdar is appearing. My lord, he is severely ill. So I'm praying for 1 week time, my lord. 15.
Senior advocate engagement of senior.
Yes, even Mr. Miller, senior advocate Mr. Miller Mukherjee is also appearing.
কবে ভাবছিস তো Wednesday
15.
1 week চাইছে 22nd
15.
on the prayer made on behalf of the petitioner, let this matter stand adjourned and be listed again on January 22, 2025.
Let it retain in the position.
Huh?
Let it retain its position.
Retaining its position.
But I will be appearing on behalf of. But I am appearing on behalf of the de facto.
Oh, I see.
I think perhaps Mr. Nondi will be appearing. He has addressed, my lord, this matter was heard 4 times before your lordships.
What is the name of the accused?
Ajay Jaiswal.
Huh?
Ajay Jaiswal. My lord, recollects, my lord, it was taken up before vacation. Your lordship was pleased.
Matrimonial dispute.
No, my lord, it was
Economic
shot.
offense, huh? Or short.
Gunshot injury. My lord, your lordships were agitated. My lord, your lordships were kept. Pleased to keep it after vacation, my lord.
Very well.
Preponing the witnesses, date of the witnesses and everything.
Taku.
I'm great.
Yes, my lord. I am petitioner.
We have already preponed the schedule of the.
Which one?
The 15.
15 is over.
16, 17 education. But I was beseeching yesterday.
I was praying for an accommodation.
I was praying for a week's accommodation.
You are praying for accommodation. Very well, 22nd.
No, my lord, anytime after 26th.
You said a week's accommodation.
Well, if it could be kept after 26th, if possible. I can only pray, my lord. 22nd to 24th, I have some difficulties.
28th.
28. 16 and 17.
Dekho, accommodation is prayed for on behalf of the petitioner as well as the de facto complainant. Paragraph as suggested, let these 16 and 17 action gache.
Yes.
Matters be listed again on
28.
28.
Deeply obliged, my lord.
Lordship, I'm praying for not today. I'm praying for not today on the similar grounds.
Mr. Mukherjee.
Time was paid for, Lordship called for a report. Lordship kindly go through the report and pass necessary orders.
Report filed by the state be kept with the records. Paragraph accommodation is sought for on behalf of the petitioner. When do you want it?
Not today.
Paragraph lists this matter once again on এই 17 তারিখ। রাখুন কি হবে এখন?
18-19 তো দুটো সঙ্গে আছে 18-19 18 আর 19
My lord, I am for the petitioner, my lord.
Lordship, I am for the de facto 19 item.
No. I am for the petitioner 19, my lord. What same case connection है बोले?
My lord.
अलग है, दुटो अलग।
18 and 19.
My lord, I am for state in 19.
এক্ষুনি আগে রিপোর্টটা কিসে ফাইল হলো?
18.
তাহলে আবার 18-19 থাকছে কেন?
রিপোর্টটা ফাইল করতে একদম হয়ে গেছে।
Since it is arising out of same PS case, my lord, that
Adjourned. One is adjourned, so therefore both adjourned.
Well,
এটা কবে হলো? 17. দাদা 19 তো আপনি ক্লিয়ার করছেন আপনি
20 ডাকুন।
Item number 20.
for the petitioner, my lord.
আপডেট হয়েছে
बोध है। My lord, the case.
It's an upgraded matter.
এর নামটা কি? হ্যাঁ এই ভদ্রলোক জি ওটা বিচার ডাকো তো। আপনি গৌতম বাবু তো? এই যে এসিও আজকে এলো না, এর বদলে আরেকজন এসিও, এর চার্জে কে আছে? কোন ডেপুটি রেজিস্ট্রার? কে, তার নামটা কি? এই হোক, তাকে ডেকে পাঠাও। বলে ডেকেছি এক্ষুনি। আপনি রাখুন, আপনি করুন না।
I am for the petitioner, my lord. But the case is under section 103 subsection 1 of BNS and section 3 subsection 5 of BNS.
That is corresponding to
302 and 34 of IPC. My lord, the petitioners are in custody for, my lord, 5 months, 8 days. What happened, my lord? Complainant's daughter and son-in-law had dispute. My lord, the complainant's son went to their place to settle the dispute. There was hot altercation. Complainant's son-in-law assaulted the complainant's son with a bamboo stick at his head. He fell down, thereafter hospitalized, and after 33 days, he expired. After 48 days, this complaint was lodged. Petitioners are father and mother of the assailant, my lord, the son-in-law of the complainant. My lord, at this stage, my lord, allegation is conspiracy, nothing.
জামাই শালাকে মেরে ফেলে।
শালা জামাই।
শালা জামাই বাবা।
না।
My lord, Jamai has killed the brother.
Although no notice was issued upon me regarding upgradation, still I am having the case there.
Upgradation? What upgradation?
Yes, perhaps this matter was upgraded.
Upgraded?
Why upgraded? 5 months custody? No, I can't remember.
And learned friends can
usual.
say that. No,
Yes.
But anyways, this is the statement which implicates this present petition.
After 33 days,
statement.
This is a statement of an eyewitness.
Yes, but would you say this is a premeditated murder?
Their role is they have instigated. As I could. Please don't.
Now, why is the assailant?
My assailant is
Mahadev.
Why? He's arrested or absconded?
No, he is in custody.
And these are assailants' parents who have come.
They are the instigators.
How long you are in custody? 5 months.
5 months, 8 days. And my lord, kindly see whether injured person, victim.
Not the principal accused. They are not the principal accused.
I have stated they are the instigators. Rest I leave.
Asun. The age is not correct, I think. No? Age 44 years, 39 years.
He is saying, my lord, that is correctly.
The prisoners claim
just
that
take leave.
they are not the actual assailant. Stop. They did not commit any offense. However, their son has been allegedly committed the murder on the spur of a moment. Stop. However, they are in custody for about 5 months. Investigation is complete and there is no chance of an early conclusion of the trial. The petitioners may be enlarged on bail on any conditions. Stop. Para. The learned counsel for the state opposes the prayer for bail vehemently. According to him, the present petitioners are the instigator, and due to such instigation, the principal accused Mohadev Haji had assaulted the deceased on his head by a wooden stick. Stop. There are sufficient incriminating materials against the present petitioner. If they are enlarged on bail, the prosecution may suffer. Stop. Para. We have considered the materials on record. Investigation is complete. The present petitioners are not the actual assailant. Stop. As the investigation is complete and there is no chance of an early conclusion of the trial, the petitioner and the parents of the principal accused may be enlarged on certain conditions. Petitioner number 1 ke
How many witnesses are there?
Well, Lord, charge sheet. I will annex the charge sheet.
19.
19 charge sheet. I am glad.
Petitioner number 1. Police station is refers to petitioner number 1. Petitioner number 2. Late.
Report does.
302 dana hai.
My
lord, I am for the petition. My lord, the allegation is under section 302. My lord, though charge sheet was submitted on 19th of January 2023, after about 2 years and 3 separate directions of this honorable court, in December 2024, only charges were framed. And on 4th January 2025, my lord, PW1 has been examined in part, deferred on the prayer of prosecution. My lord, there are 18 total, charge sheet? My lord, there are total 16 charge sheeted witnesses. We are in custody.
My lord, the
2, my lord, these 2 only.
So you are not responsible for any direct.
No.
He is directly involved.
My lord,
let him submit whether as to he is taking the plea of period of detention or on merit. If on merit, there are ample 161.
My lord, I have only
if on period of detention, my lord, the report says, wait 1 minute, that PW1 has been examined. Rest will be examined on the 17th of March, 18th of March, and 19th of March.
My lord,
Within three days, you will.
No. The PW1 has been examined. The other witnesses are scheduled is 17-3, 18-3, and 19-3. Definitely not 15 will not be completed in course of 3 days.
PW1 has been examined in part, deferred on the prayer of prosecution. And after 2 years from the date of charge sheet, My lord, after 2 years from date of filing of charge sheet, the charges were framed after 3 separate directions from this honorable court. My lord, the case is based on no. My lord, circumstantial
Yes.
evidence. It
300
was
300
Sir, আপনি তাহলে বলে নিন, তারপরে আমি বলবো। My lord, the case is based on circumstantial evidence, and my lord, these petitioners were arrested on the basis of extrajudicial confession made by Abdul Sahil.
Petitioner number 2, both the petitioners suffered rejections.
Yes. My lord, on merit, they have suffered rejection, and while rejecting our prayer for bail, on 3 separate occasions, directions were passed, my lord, to frame the charge. Charges were not framed till December 2024, though charge sheet was filed on 19 January 2023. So, my lord, this is the indolence of the prosecution. My lord, 2 years to frame charges, and my lord, that too, there are 16 witnesses, 1 witness in part, and deferred on the prayer of prosecution. My lord, this is the witness of PW1. My lord, who stated that he is a hearsay witness. My lord, everyone is a hearsay.
My lord, on merit wise, my lord, your lordship have rejected this matter several times. Offending weapon was seized from the petitioners. There are a number of 161 statements.
Taken so much time. We are considering.
In the outset, I have said, if your lordship is taking on the period of detention, my lord, lordship will kindly consider the report. That is maximum that I can submit, my lord. And the last page is the order passed by the court below.
19 January 23, my lord, charge sheet submitted, and charges framed December 2024.
So far the delay in trial is concerned, my lord, the report will speak for itself, my lord.
It says nothing. It doesn't say that he is responsible.
My lord, the report, if your lordship wants such kind of report, my lord, to
issue. Abdul Sahil. Acha. Tipu number 2.
My lord, number 2 is MD Tipu. Alias Tipu.
The petitioners renew their prayer for bail, which was rejected on merits earlier. Stop. They say that they are in custody for more than 2 years. Stop. Only 1 out of 16 charge sheet named witnesses has been examined, and that too, in part. Stop. On the touchstone of Article 21 of the Constitution of India, they pray for bail. Paragraph. Opposing the prayer, learned APP draws our attention. The state has filed a report. Stop. Let the same be kept with the records. Stop. Paragraph. Learned APP, opposing the prayer for bail, draws our attention to statements of witnesses recorded under section 164.
161.
161 CRPC.
As also the Caesar list.
It cannot be said that there is no incriminating material against the petitioners at all. Stop. However, we see that the petitioners have been in custody for an appreciable period of time. Stop. There is very little progress in the trial. Stop. The prosecution may have an excellent case to secure the conviction of the petitioners. Stop. Nobody stops them from doing so. Stop. However, a trial cannot be kept pending for an indefinite period of time, keeping the accused persons in judicial custody all throughout. Stop. This would militate against the fundamental principles enshrined in Article 21 of the Constitution of India, which must ordinarily override all other considerations. Paragraph. Without touching the merits of the case and solely on the ground of long detention of the petitioners, coupled with very little progress in the trial, and seeing that an early conclusion of the trial is highly unlikely, we feel constrained to enlarge the
Lordship will
petition.
kindly impose one condition that he shall he shall attend the trial court on each day, and failure of which the trial court will have the liberty to cancel his bail, my lord, without any risk.
This is there in all our bail orders.
I am sorry.
Not to enter Muddungam PS jurisdiction excepting for the purpose of attending court proceeding.
My apology, my lord.
Breach of any condition, trial court will be at liberty to cancel without reference to us.
I am sorry, my lord.
Not to enter, just not to enter Muddungam PS jurisdiction, and he shall inform the IO and the trial court the current local address and shall meet the OC of the local jurisdictional police station once in every week.
My lord, the report that I have filed, my lord, be kept with the record. My lord, the report.
এই দেখো তো
নাম দিয়ে দে আর সিজেএম বারাসা
দেখাতে বলবো 10টা যে আরো এক বছর লাগবে কোথায় বলেছে কোথায় দেখে বলো এতক্ষণ নিয়ে বসে থাকছি
ইনি জাস্ট 5 মিনিটস আগে ঢুকলো, তাই তো 5 মিনিট আগে ঢুকেছেন। আমি সব দেখি এখানে, আমার এখানে নিজের চোখটাই একটা সিসিটিভি ক্যামেরা। আপনি দিয়েছেন বললেন যে 5 মিনিট আগে দিয়েছে।
লুজ কেন রে?
আপনার কোর্টের কলার ঠিক নেই, ঠিক করো।
Train somebody who can manage the affairs. Do it now. 5 মিনিট আগে দিয়েছে। We are going to take steps to go. Yeah. Go. Call the matter. Call the list. শুনুন, আমরা যদি রেগে যাই
Item number 22.
22, my lord, I am for the petitioner. Your lordship, please to call for the report as status report. My lord, let me have a copy of the report. My lord.
Status report is rigid.
হ্যাঁ ঠিক আছে দে না।
My lord.
Make it not okay, my lord.
Report's copy. My lord, if you lord, that will transfer from your lordship's order. If your lordship kindly considers the last page of the report, only a year from the date it will require to complete the trial. It's a case of 302.
You want to consider this report?
Yes.
Who consider. Report filed by the state in terms of our order dated January 3, 2025, be kept with the records. Paragraph, a copy of the report has been made over to learned advocate for the petitioner একটাই আছে, who seeks a little time to consider the same and come back. Paragraph, list this matter once again, 22nd.
হ্যাঁ
দাদাকে একটা রিপোর্ট জেরক্স করে দিয়ে এখনই
Item number 23. I am for the petitioner.
What is here? It is not replaced.
No, my lord, Mr. Ranadev Sengupta is on his legs. My lord, he has requested me if the copy of the evidence could be handed over, then he will come back.
কি গৌতম?
Subject to your lordship's correction on Friday.
May I please?
Yes. May you?
Please the bail application.
Your other side is not there, sir. You can see that. Give her a copy. She will give it to Mr. Sengupta.
How long you are in custody?
4 years, my lord.
4 years.
Yes, my lord. Out of, my lord,
of PW1 is going on.
my lord, on the last occasion also, my lord,
Sorry.
no, my lord. On the last occasion, my lord, the PW3 was not present, my lord. The 6th of this January 2025. Well, out of 25 witnesses, only 2 witnesses examined, my lord.
Next.
Copies of the witnesses examined so far have been made over by learned advocate for the petitioner to learned State Counsel, who is holding the brief for Mr. Ranodeb. Miss Ratna Ghosh is appearing.
Yes, my lord.
Along with Ranodeb
Mr.
Sengupta.
Sengupta.
Achha, Mr. Ranodeb Sengupta. Stop. Paragraph. List this matter once again on Friday. Shukrobar, মানে 17 তারিখে. Stop. On that date, learned State Counsel shall apprise us to what extent the witnesses who have been examined implicate this petitioner.
Please, my lords.
But I have instructions to appear for the de facto.
My lord, I am one of 18 accused persons in custody over 1 year, 11 months, my lord. My lord, charges are, my lord, 147, 148, 149, 302, 307. My lord, the earlier rejection was on, my lord, 25th of August 2023. My lord, post thereafter, my lord, the developments were, my lord, some of the co-accused persons were granted bail. And to my lord, submission, kindly, my lord's pleasure will be to come to page 30. I am on a much better footing than the accused who was granted bail, my lord, at the order at page 30.
How many witnesses have been examined?
My lord, 6 out of 46.
I'll tell you, your lordship. My lord, after a lot of difficulty, my lord, the charges could be framed because the accused persons were seeking time. Charges could be framed, my lord, only on 20th of May 2024. And the order that my learned friend is referring to at page 30, which I understand, my lord, your lordships granted due to, my lord, non-examination of the witnesses. My lord, even thereafter, after that order was passed by your lordship, another co-accused's case was dealt by your lordships. And despite, my lord, that order at page 30 being produced before your lordships in connection with this case, because the order at page 30 is of 24th of June 2024. And this your lordships considered on 19th of July 2024. This is not annexed with the petition. My lord, this is not annexed with the petition, my lord. This, despite, my lord, noticing that your lordships have granted bail to my lord Tausif, your lordships have rejected the prayer, my lord. And so far as, because one of the reasons was that those accused persons were trying to, my lord, delay the trial and the framing of charge. My lord, charge has been framed, my lord, on 20th of May 2024. My lord, 6 witnesses, my lord, subject to correction has been examined. And kindly see the orders of the trial court on the last 2 dates, my lord. 31st of July.
The copy of the depositions.
Kindly see the last 2 trial court orders, my lord.
My lord, then I will argue after Mr. Chatterjee finishes, my lord, because I was arguing, he just
Since your
interjected.
lordships have posed a question to me, my lord, I was responding to it. 31st of July, your lordship will find, my lord, that they have filed a 231 petition. And also, 3rd paragraph from the bottom, senior counsel for the defense was absent and an adjournment was sought for on his ground. This is 31st of July. And then on 14th of November, again a 231 petition was moved for deferment of, my lord, cross-examination. So, my lord, they are, my lord, delaying.
You must first notice whether we are listening to you or not.
My lord.
We were trying to read something.
I'm sorry.
You're a senior advocate now.
I'm sorry.
Will you consider all this or come back?
My lord,
yes.
He was the main accused.
She's going to submit some depositions.
All depositions I have.
Well, I tell you, lordship, he was the main accused whose bail was rejected. Page 30 or
who? Nashish?
Nazis, because that is recorded in your lordship's
Yes,
order.
yes, principle as
In this incident, my lord, one person died. The implication of that gentleman, so far the death of that person is concerned. Another person was injured, my lord. So far I am concerned, my complicity OA 307. Now, my lord, page 30, the accused was granted bail. Against that, my lord, which was not submitted to your lordship, there is a special leave petition filed by the de facto. Now, my lord, special leave petitions to dismiss by the Honorable Supreme Court. My lord, I am much better footing than the accused person, my lord, who was granted bail by your lordships at page 30.
State.
My lord, I have the deposition.
And my lord,
No,
one.
Please tell us.
My lord, I have
SLP
seen
notice
that
or copy.
the one who
Copy
was granted bail
Yes.
was granted bail not on merits but on the ground of delay in trial.
Yes.
So far as the merits are concerned, that person who was granted bail assaulted a person. His name transpires in the depositions. So far as this petitioner is concerned, on merits, his name transpires, my lord.
So on the at least on the same footing.
Yes.
And so for the report filed, my lord,
You also assaulted.
the person who,
Not be the
right, my lord, so my lord, 307, my lord,
just a minute. You assaulted.
my lord, the death was by defenestration and there was bullet injury. Now the person who hit the bullet, my lord, was the person whose bail was rejected. And
how many victims? One?
One, my lord, one person died, another person survived, who is CSW 27.
Whom did you beat up?
PW to CSW to 27, my lord.
Survived.
Right, my lord. And my lord, kindly sees, my lord, the report filed by the state.
My lord, he has deposed also. His
And my lord,
deposition was there, he has named.
And my lord, kindly sees the state report so filed. The delay was on the ground that one of the accused persons could not be produced, was in custody, so it's not on my fault.
Yes, Mr. Chatterjee.
And my respectful submission is the framing of charge was delayed because systematically there are a number of accused, they were, my lord, seeking time. That your lordships have considered in the earlier order. Thereafter, my lord, charge came to be framed, my lord, only on 20th of May 2024, my lord. It's not that the charge has been
examined.
Already 6 have been examined.
Out of 46.
Out of 46, and I have handed up 2 trial court orders to your lordships, where their senior counsel has sought for time, and where they have moved, my lord, deferment applications of cross-examination.
Did you file any report today, state?
But on the earlier occasion, they had filed a report, copy thereof was
on merits, a person.
Have you mentioned how many witnesses you propose to examine?
No, my lord.
You not.
We have examined 6.
The tailor down porbe kina seta.
We want to know.
Lords.
My
want
lord,
to
then
know.
we will wait.
Friday, we'll keep it on Friday, only on this point.
My lord.
Huh?
But whether they would
And
like
so far
to...
the delay is concerned, my lord, it's only on one occasion, my lord, the time was taken on our behalf.
We are told that 6 out of 46 charge sheet named witnesses have been examined. Stop. The petitioner is in custody for about 1 year, 10 months.
11 months, my lord, over 1 year, 11 months. 23 days short of 2 years, my lord, now.
Over 1 year, 11 months. Stop. Paragraph, we would like to know how many more witnesses the prosecution.
Then we will come after the next schedule.
When is the next schedule?
From 5th of February to 7th of February.
That's quite a few days again.
Right.
7th of February.
Only this.
My lord, the reason being, my lord, if my lord's pleasure will be to see this order only, my lord, second last paragraph. My lord, one person is in Darjeeling. One person is Darjeeling jail. That's the difficulty
not
of his production is concerned.
Virtual.
How many more witnesses?
Even my lord, that they failed, my lord.
Intends to examine. Huh? Paragraph now. Let a short report in that regard be filed by the state on the next date. Friday? This Friday. List the matter. Huh?
My lord, I'm on equivalence and 21 both, my lord.
But Friday would be too early because
22nd. 22nd.
Effect coming.
অনেকদিন ধরে আছে remaining 2 marks.
25.
My lord, on behalf of Mr. Mukherjee, I'm praying for
About
not
de
this
facto.
week. On behalf of Mr. Mukherjee, I'm praying for not this week, my lord.
Okay.
Should ask for a status report then. Lordship.
How long are you in custody?
My lord, 1 year and 9 months. My lord.
Accommodation, accommodation is prayed for on behalf of the petitioner. Paragraph, let this matter be listed again on 22nd. January 22, 2025. Paragraph, since the petitioner complains of delay and says that he is in custody for about 1 year, 9 months, let the state file a status report on the next date. Stop. The report shall indicate, inter alia, how many witnesses the state has already examined and how many more witnesses the prosecution proposes to examine.
For de facto,
Obliged.
Item 26.
My lord, I am appearing for the petitioner. This is a case under section 498-302. Husband before your lordships, my lord, it's a sole accused before your lordship. My lord, I am 1.5 years, I am languishing in jail. After, my lord, 38, my lord, August 2024, thereafter no witness turn up because Alamat was not.
Mr. Mundul, read our order and just take it up from there. Where's the deposition?
Sorry. Yes. Well, from 4 witnesses, well, they are all relative of the victim. There is no direct evidence so far 302 is concerned, but so far
have you considered the depositions?
498 is concerned, my lord.
Everywhere petitioner name is there, my lord.
And he's the sole accused.
These are also the offending weapon. That is, my lord,
Sole accused.
Yes, well, sole accused husband. They are consuming.
Progress, my lord.
No, my lord.
No,
My lord, so far 302 is concerned, my lord, there is no. So far, no.
Mundul stabbed her with a knife.
Yes.
No, my lord, they are not present. They are the hearsay evidence. They are the relative of the victim, lady. They are the petitioner is a husband. My lord, 4 witnesses. My lord, kindly hear me. My lord, the 4 witnesses all are relative of the victim. My lord, 4 witnesses examined. My lord, August 20.
They are not the eyewitness.
No. My lord, August 2024. After August 2024, there is no witness because there is Alamat. It was sent for FSL report. It was revealed from the order sheet dated. Well, kindly go through. I have annexed the order. Well, kindly order number 13 first. Order number 13.
13.
Yes, my lord. On 38 August 2024, no witness present.
Number 38.
13.
No PW turn up.
Yes. My lord, thereafter, one my lord, investigating officer pair for my lord Alamat produced before the court. That was sent before the FSL examination. That was not, my lord, came back. That's why, my lord, they prayed for prosecution, prayed for time, and no witness present. My lord, next date, 25 February 2025. That 1.5 years I am in languishing in jail. My lord, their husband and wife used to consume later. 29 years back, my lord, marriage was solemnized. They used to consume liquor, and my lord, it was norms. After my lord, taking repulse, they used to quarrel each other. Well, kindly go through the no. Well, kindly go through the 164 statement of yes.
Yes. How long are you in custody?
My lord, 1 year, 1.5 years.
Speed is not.
Thereafter stall.
How many examined? 4.
4 out of 13, my lord. Trialing in progress, my lord.
4 out of 13.
Out of 16.
Only
16 witness charge sheeted.
They wish to. Acha, have you filed a status report?
yes, miss. Fine.
Kothay?
Earlier occasion I filed, my lord.
Have you mentioned how many witnesses you propose to examine?
No,
Then what is the status report about?
that is because filed, my lord. Out of 16, my lord, 4 witnesses have been examined, my lord.
We had specifically ordered, recorded in our order dated 17 December that you shall file a report indicating how many more witnesses you propose to examine.
I shall file, my lord.
Either you don't read the orders that we record or your officers don't understand English.
I shall file, my lord.
Mr. Mondol, I was trying to go through the deposition. We are not going to assess the quality of the evidence.
As you,
So
as your lordship.
it is not that there is no evidence against you.
No, there is a, so far torture is concerned, there is a allegation.
Even the PW2, for example,
Yes, my lord.
the Puleshwar is the victim. Puleshwar's elder sister's husband.
Yes.
His deposition I was reading also. Anyway, let them come back.
My lord, the trial will not progress because Alamot is lying in the FSL. That's why August 2024, no witness.
Please also, do you have a copy of the deposition?
Yes, ma'am.
Another copy?
Yes, ma'am.
Give him.
এটা দিয়ে.
Copies of the depositions of the witnesses examined so far have been made over by learned advocate for the petitioner to learned advocate for the state. Stop. Learned advocate for the state is requested to scan the evidence and tell us on the next date, comma, to what extent, comma, if at all, comma, the said witnesses implicate this petitioner. Paragraph, a report should also be filed on the next date indicating how many more witnesses the prosecution intends to examine. Paragraph, list this matter when? Friday or next week, Wednesday?
Wednesday, my lord.
22nd. কাকে? হ্যাঁ, ও জানে আমাদের সঙ্গে কাজ করেছে। হারুন ভাই, এবার আজকে উদ্ধার করে দাও। তাহলে যতদিন এই জগৎ আছে মাসের শেষ অবধি এই
State লিখা নেই,
Well, in 27, I'm seeking for a day's accommodation and leave to file a supplementary matter because a supplementary charge sheet has been filed while this application was pending. Subsequent to your lordship's order on the last date, we had to file an application under 207. Then state has given us the documents. So
leave is granted to the petitioner to file supplementary affidavit by.
My lord, we'll file it by Thursday and serve it on the de facto and statement.
By পরশু দিনের ডেট দাও, comma, with advance copy to learned advocates for the state and the de facto complainant. Stop. Paragraph, list this matter once again on Friday date দিয়ে দাও. Not today.
Not this week, my lord.
Not this week.
My lord, I am for the petitioner.
No, you are for the petitioner. Who is for the state?
My lord, on the last occasion, my lord, your lordships were kind enough to grant me leave to file a supplementary affidavit enclosing the depositions. My lord, this is my supplementary affidavit. I have given a copy to my learned friend in advance. My lord, 498, 304B, 302.
Mother-in-law.
My lord, there are two petitioners. One is the mother-in-law, two is the husband. My lord, only, my lord, your lordship will consider this, my lord, that so far as the husband is concerned, my lord, the only material against him subject to correction is, my lord, recovery of a bamboo stick from his house. Now, my lord, bamboo stick, as your lordships know, my lord, it's a household item. And my lord, the seizure list doesn't disclose that there were any blood stains. And my lord, so if your lordship would see the post-mortem report, my lord.
Cause of death?
My lord, in the post-mortem report, no, if your lordship sees
Blunt
the
weapon.
If your lordship sees the post-mortem report, my lord, there is no indication of a blunt weapon, but all the other injuries, my lord, are on the left thigh. And there is one injury, my lord, which is subdural hemorrhage under the surface of the brain. My lord, subject to correction, this may be caused due to falling. My lord, only two circumstances, my lord, if your lordships consider. Kindly see, my lord, the 164 of the, my lord, mother of the victim, my lord. In the 164, the mother, Kaushalla, she says, Amar me Janaki Mahato amake phone, this is on in respect of the date of occurrence. Amar me Janaki Mahato amake phone kore, হাসি খুশি অনেক কথা বলে এবং বলে ওর জেঠ শ্বশুরের ঘাটে ওঠার জন্য যা লাগে তা দিতে তারপর আমার জামাই ফোন করে বিকেল বেলা জানায় যে মেয়ে ছাড়া দিচ্ছে না মিলট সো মিলট it is not that she was being subjected to a repeated torture milord and secondly milord if your lordship sees the deposit
Wife died.
Lord, she fell down, my lord. She fell down.
Taken to her.
No, I was there. I immediately.
Doctor.
My lord, that is the evidence of the 164 of the mother. And my lord, on doc also the mother says that immediately after the occurrence, my lord, I called up the parents of the deceased. They came. The husband didn't abscond. He was there with the wife. The in-laws came. And then even my lord, in the deposition.
In custody.
My lord, so far as my lord, the mother-in-law, 6 months, husband, my lord, more than 7 months.
Deposition it says.
And my lord, in the deposition, if your lordship sees, my lord, there also it is recorded that I did not abscond. I was there.
Within 7 months, deposition started.
Lordships. My learned friend, my learned friend.
Appreciate the space.
No, so have you read the evidence? Have you gone through it?
They gave us a copy.
Page 5, my lord, cross-examination of the mother.
Why cross? We'll first see the chief.
Kindly see the chief.
How many witnesses you have? 13.
13, 1-3.
How many already examined?
Two.
Two examined.
My lord, any stringent condition, my lord. I did not abscond.
Implication is?
But within a year of marriage.
We are kind of consider 50-50.
50-50.
My lord, kindly consider, my lord, internal page 3 of the deposition also, which records that we took her to the hospital. The husband did not abscond. He was there. He informed. My lord, kindly consider more than 7 months.
Allegation is there.
Kindly.
In deposition, it says that they used to torture.
My lord, we did not delay that trial.
Not on delay, madam.
On merit, they cannot be granted bail because they were in the house within the 4 corners within a year of marriage.
Yes.
Died of injury.
Which law says they can't be granted bail? I mean, where's the bar in law?
There's no bar in law, but after a week, they will come claiming same footing again because.
No, there are two accused, mother and son.
May not be 50-50, maybe 100%.
Yes.
On merit, I'm sorry.
Really?
Fine.
Investor complete.
The petitioner number 1 is the mother-in-law and the petitioner number 2 is the husband of the deceased lady. Stop. They say that they have no role to play in the death of the victim lady. Stop. The death was accidental. Stop. She fell down and suffered injury in her head. Stop. She succumbed to such injury. Stop. They took the victim to hospital.
Lordships.
Hospital. Stop. However, she was declared dead. Declared brought dead.
She was declared dead.
declared brought dead within inverted comma. Stop. The petitioner number 1 is in custody for about 6 months. Stop. The petitioner number 2 is in custody for about 7 months. Stop. They pray for bail. Paragraph opposing the prayer, comma, learned state counsel draws our attention to the depositions of the 2 witnesses already examined before the learned trial court. Stop. She also shows us statements of witnesses recorded under section 164 CRPC. Stop. She further tells us that the trial is progressing at a satisfactory pace, and there is no delay in that regard. Paragraph, we have considered the material on record. Stop. We have also seen the post-mortem report. Stop. Nothing appears to have been seized from the petitioners or from the household excepting a bamboo, and that too without any blood stain. Stop. Most importantly, comma, investigation is complete. Stop. The trial is proceeding. Stop. We see no useful purpose in further detaining the petitioners in custody. Stop. Paragraph accordingly.
I'm deeply obliged.
ওই পুলিশ এখানে রিপোর্ট করতে হবে না।
সিজেএম পুরুলিয়া। I'm deep.
Please, my lords. Well, this was earlier heard by your lordship. 302. I am in custody over 1 year, 5 months. But the only prosecutable evidence is, my lord, broken brick stained with blood. Now, my lord, in the supplementary affidavit, the report was filed that the blood was found to be inconclusive, which your lordship, for which, my lord, my learned friend wanted further instruction on this. My lord, just to satisfy your lordship, one thing, my lord, my learned friend placed an order of rejection of co-accused by this honorable court, my lord, being presided over by Justice Bakchi. My lord, the order was passed on 15th of April 2024. And supplementary affidavit, whereby, my lord, this additional circumstance, rather, my lord, this was placed before the court, is in August 2024. So when that order was passed, my lord, the blood report was not, neither the examination was conducted nor it was filed, my lord.
Blood stain brick.
My lord. This is the supplementary affidavit. Sorry, my lord, charge sheet they have filed.
PM report, cause of death.
My lord, cause of death, my lord, assault, my lord. That is, my lord, from the brick, my lord, he was the disease was murdered by a brick, my lord. In the brick, my lord, blood stain was found. My lord, there are, my lord, human blood was there. My lord, kindly see the report. Human blood, but my lord, this is because it is inconclusive. The group also, my lord, determined, but there is AB group. But my lord, in the in the pant, in the gauge, in the shirt, my lord, the amount of blood, my lord, my learned friend is well aware of that fact. My lord, this amount of blood is very little. My lord, that's why, my lord, honorable apex court also, my lord, in several divisions, my lord, they have stated that this is not the conclusive proof, my lord, that if that is inconclusive in the FSL report, the blood group has come, my lord, then this is not a benefit of doubt of the accused, my lord, to get that grant of bail, my lord.
No, bail or conviction.
My lord, in this not
Those cases must be on conviction.
My lord, but this is a human blood, my lord. This is not that, my lord. This is a blood of dog or my lord.
And this brick was seized from
Yes,
him.
my lord. Pursuant to his statement, 27.
Not from my possession, my lord.
No, my
leading statement.
Well, that's the only evidence they have. The blood group did not match. And what the blood group, my learned friend said, that's, my lord, in the...
And my lord, last seen together, evidence is there, my lord.
And there is no other evidence against me, my lord.
Leading statement is.
But that's a brick, my lord. Brick will be available anywhere, my lord.
Proximity, my lord. On 29, the deponent.
My lord, brick will be available anywhere, my lord. Kindly appreciate, that's the process.
My lord, on 29, the 160 was statement.
Blood did not match.
So, my lord.
How many witnesses in the charge sheet?
My lord, total, my lord.
27 witness.
How many have you examined?
One, my lord.
How many do you propose?
My lord, charge framed, my lord, in the month of September. Thereafter, my lord, we have examined one time.
Charge sheet filed when?
Charge sheet filed, my lord, on
2023
2023
September.
Thereafter, my lord.
So
the
one
charge-
1 year you took to frame charge,
Yes, my lord.
right? And
One-
then why?
My lord, that then.
How many accused?
Two.
Two accused.
No absconsion. Nobody was absconding. So 1 year for framing charge, 1 year for one witness.
Yes, my lord. FIR, my lord, 20.
So 26 witnesses.
27, my lord.
27 years for the trial.
No, my lord, nothing it could. My lord, then I will have to take
How
instruction.
many witnesses you propose
My
to
lord, that
examine?
I take instruction, my lord.
Please.
My lord.
What have you filed this?
Well, this is the regarding the FSL report. Lord, she was pleased to direct me to file a report regarding the
hearing.
next date, my lord, that I also, my lord,
Hey,
My lord, for further chief of PW1 today.
the
It is only the brick, my lord, which is used against me.
petitioner says that
And the
he is-
blood group did not match.
he is in custody for 1 year, 9 months.
My lord, 5 months.
1 year, 5 months. Stop. Only one out of 27 charge sheet named witnesses has been examined. Stop. There is no material on record to implicate him in this alleged crime. Stop. Paragraph. Let the state file a status report which shall indicate inter alia, comma, how many more witnesses the prosecution proposes to examine. Stop. The state shall also indicate the reason for the delay in progress of the trial. Stop. We may put on record that charge sheet was filed in September 2023 and it took 1 year for the charge to be framed, which was done in September 2024. Paragraph lists the matter. Friday or next week?
my lord, next week.
22nd then.
Well, only PW1 is going on. It's not completed even. The chief is going on.
He will see only 1 out of 27 charge sheet named witnesses has been examined, comma, that too, comma, in part.
Most of them.
Fine. Leave you.
My lord, may please the lordship, see my application in 31. My lord, this is my renewal prayer. There are the successive.
Who is in 32?
I'm being led by Mr. Mukherjee in this matter. Your lordship is only praying for not this week, your lordship.
My lord, 31 is totally different from the other scooting. My lord.
Why have they been clubbed together then?
My lord, this is
We did not do it.
No,
It
Absolutely. On the prayer of our
Yes.
heart. না আমি বলেছি কি তুমি বলছো সেম কেস ডায়েরি মানে সেম accused person সবচেয়ে same case, it has to be previous case.
If you want to press 32, you can press.
My lord, 31, my lord, I'm pressing. 31.
31, press. 32 will make not this week. ঠিক আছে যাও 32 টা আর ওটা তুমি এক কাজ করো ট্যাগ না করে আলাদা পরপর করে
দুটো কপি দিয়ে দশটা
Because my lord, that is not filed by me. Therefore, my lord, I have no knowledge regarding 32, my lord. My lord, this is my renewal prayer. Admittedly, my lord, on these circumstances, my lord, I am praying, my lord, renewing my prayer. Page 17, my lord, kindly come to page 17.
NDPS.
No,
No,
page
madam.
from 302, my lord.
302 minutes brutally murdered.
302.
Brutally murdered. Mr. Chatterjee is the main kingpin
NDPS court
behind the scene.
is being tried in NDPS court.
My lord, yes,
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 special
yes,
court.
that
Special
special,
court.
the trial is going on in the special court. That's why, my lord, this designation has been, my lord. My lord, page 17, my lord, kindly come to page 17, one second.
Rejection.
No, my lord, thereafter, my lord was.
Where is
pleased
your
to-
rejection?
My lord, my rejection is, my lord, the.
Series of rejection.
Yes, my lord, last in February.
But that your lordship, to cut short the matter, your lordship was pleased to allow one of the co-accused who is the principal. And against that, it was preferred that your lordship's order was sustained. Your lordship granted bail due to the only for the period, not for delay on the part of the prosecution. Your lordship has observed that order. And he is praying for parity. My submission subject to correction by Mr. Chatterjee, my parity cannot, the councils are different.
My lord, I have no case.
How long are you in custody?
My lord, more than
Well, this is
4
the-
years, 10 months.
Oh, this
He was.
Months.
4 years. 4 years. 4 years. 10.
4 year 10. Right.
He was 4 years, 5 months. I am
But
10
my lord,
months.
your lordship call for the report, my lord.
He was
We have-
PI parent identified, principal accused. I am not.
There is no delay on the part of the prosecution. We have tried 20
There is
witnesses.
the
has
order
been-
whereby you said we granted
My lord,
principal
17,
accused.
page 17, 17 in my application.
That's
Principal
why, my lord,
accused.
he was pressing 70.
Principal accused.
Yes.
If I name accused.
If I name accused, my lord, I was not if I name.
I'm not
No, 94 out of
My lord,
which 55 we have come.
There are 94 witnesses. State proposed to my lord examine 40. That was also observed in my lord order.
Propose, my lord, you're likely, my lord, your lordship that. That's
issue. The petitioner cites an order dated September 2, 2024, passed by us, passed by a coordinate bench.
Yes.
In CRM DB 2140 of 2024, whereby a co-accused person was enlarged on bail primarily on the ground of lengthy detention. Stop. The petitioner says that he is similarly circumstanced insofar as the period of detention is concerned. Stop. He renews his prayer for bail, which was earlier rejected on merits on several occasions. Stop. Paragraph. Learned State Counsel, while opposing the prayer, in his usual fairness, does not dispute that this petitioner is similarly circumstanced as Shushanto Kirtonia, alias Dholu, who was granted bail by the aforesaid order dated September 2, 2024, insofar as the period of detention is concerned. Stop. Paragraph. We see that this petitioner is in custody for about 4 years, 10 months. Stop. How many examined?
We have indicated, my lord, your lordship, 35 more witnesses we intend to examine.
The state, as would appear from the,
Likely to examine.
As would appear from the report filed by the state in court today, the prosecution proposes to examine 35 more witnesses. Stop. Therefore, an early conclusion of the trial is not possible. Paragraph. In view of the aforesaid and also on the ground of parity, we are inclined to allow the petitioner's prayer for bail.
That's why, my lord, your lordship, we prayed for analogous. Otherwise, we
I see. Page 17 যে bail orderটা আছে তার condition যা হবে same condition.
CGM Alipur.
Deeply.
My 32, your lordship.
Not today, Mr. Viran Mukherjee.
Could have been passed. Similar order could have been passed. Only
She asked for time.
Only the period of detention is different. 4 years, 7 months.
Same order, but then she asked for time.
Your lordship, in number 33, I'm praying for not this week.
33.
33.
Paying for only these day accommodation.
Huh?
Paying for these day accommodation.
Mr. Mukherjee again?
No.
Not today. Not today.
Not today.
Chalo nahi.
I'm for the petitioner, later Mr. Rohit Jana.
Where is my bill?
My lord, on the last occasions, the lordship's pleasure was to call for a report. Out of 42 witnesses, my lord, only 7 are examined. My lord, this petitioner, she is a lady. She is in custody for 1 year, 3 months. I am renewing my prayer for bail.
There is substantial progress, my lord. If your lordship kindly consider, charges were framed on 6th of August. My lord, 8 witnesses have been examined since then.
8 or 7?
8.
Achha.
1, 2, 3, 5, 6, 4, 8, 9. Total 8 have been. The next schedule is 10th, 11th, 12th, 13th of February. My lord, two persons have been granted bail, certainly not on the same footing. My lord, if your lordship kindly considers the earlier rejection order, lordship will have a fair idea, my lord. My lord, there is progress.
There are 42 prosecution witnesses named in the charge sheet.
Yes.
How many have you mentioned? How many you intend to?
Not stated specifically, but if your lordship kindly sees, they have mentioned rest 34 are yet to be examined.
That means nothing.
That means, my lord, they are going to examine the rest 34.
Yes, where is the rejection?
My lord, the rejection is dated. I have annexed it, page 9, dated 22nd February 2024.
Showman is in custody.
Yes.
Showman is in custody. My lord, two persons they are granted bail. One is Ajmal Sheikh and another is Sudip Das. Showman is in custody.
Been rejected. My lord.
Ajmal.
On 18th of September, prayer for bail of Ajmal has been rejected.
Who is Azizul?
Not in. No, Jahangir and Sudip.
No, Azizul murdered the victim. This is recorded.
Yes, Ajmal is the person who has committed this offense. Now, this lady, my lord has seen the order. So far, the rejection order is concerned dated 22nd February. My lord.
His allegation that he hired Azizul who committed murder.
Yes.
Now, my lord, whether I hired, because on the last occasion I most humbly submitted one thing, my lord, which my learned friend Mrs. Sinha also
became
did not
pregnant by Showman.
No, yes, I tell you, lord. My lord, who is she?
Who is she?
Yes,
she's Rakhi Das.
She is the Helen of Troy. My lord, the two persons they are fighting for her. She was having an extramarital affairs with another person. My lord, that is the whole reason. Now a lady.
Who are you?
No, my lord, she's assisting.
Now, my lord, a lady accused. She is in custody for 1 year, 3 months. My lord, there are altogether 42 witnesses, which my learned friend has not disputed. Even the report says that the prosecution is intending to examine all the 42 witnesses. 7 or 8 are examined. Most vital witnesses, they are examined. My lord, may I tell you, lordship, one?
Merely by mentioning
perhaps
she had the wit to conspire. She is the mastermind. My lord, she has used the husband's money.
How do you know she is the mastermind and not Showman?
No, my lord, if your lordship kindly sees, the money that was handed over to Showman belongs to the deceased.
Yeah, that's all right.
So, my lord, even she is interested in getting rid of the husband. It's not only that Showman, my lord, everywhere.
My lord, may I join the issue? May I just take advantage of the sentences, my lord? She wanted to get rid of her husband. Why she wanted to get rid of her husband?
How is that she was pregnant by Showman?
Well, there's document. There's medical document to that effect.
That is the.
There's medical document to that effect.
That is the only document. You show us.
And my lord, there are 164 statements.
My lord, now my lord, so far, very well. My lord, so far the extramarital affair is concerned, that sections has been made, my lord, declared unconstitutional by the Supreme Court. It is so far the extramarital affair is concerned. There has to have a added section under 498 only. That too by the deceased, it's not 498A. It should be 498. It should be 498, that too by the deceased. My lord, kindly sees 498 of the IPC, previous IPC, which says it actually give a right to the husband to lodge a complaint against a person who cohabits with his wife.
Had he
Heard you?
So, my lord, all I am trying to say is the lady accused.
What you are trying to say, you have said. Issue.
But my lord, a lady accused can consider her. But that will not actually help Showman to get out of
Don't underestimate ladies at all. They are much more powerful than men. With all due respect, I say this.
My lord, I bow down to your lordship.
My lord,
The
in that
petitioner
event,
renews his prayer
can
for
there be a general direction for expeditious
Yes,
process?
yes. Petitioner renews his prayer for her prayer for bail, which was rejected earlier. Page.
My lord, page 9. Page 9 of my application.
Earlier on merits by an order dated February 22, 2024, passed by a coordinate bench in CRM DB 454 of 2024. Paragraph. The petitioner says that she is in custody for 1 year, 2 months.
3 months.
3 months. Stop. There are 46.
42.
42 charge sheet named witnesses. Stop. Only 8 witnesses have been examined so far. Stop. There is delay in progress of trial. Stop. Considering that she is a lady, she should be enlarged on bail. Stop. She has 3 children to look after. Correct? No.
No, I do not have any such.
Justice Bagchi records that.
2 children, perhaps.
Mother of 3 children.
May I check my?
She has children to look after. Paragraph. Opposing the prayer, learned APP tells us that there is substantial progress in the trial. Stop. After framing of charge on August 6, 2024, 8 witnesses have already been examined. Stop. It is possible that the prosecution may not examine all the charge.
My lord, kindly do not record that because the report otherwise indicates that they intend to.
You're right.
Examine.
You're right. Stop. A report has been filed by the state, which we kept with the records. Paragraph. We have considered the material on record. Stop. It prima facie appears that this petitioner entered into a conspiracy with her paramour to eliminate the petitioner's husband. Stop. Prima facie sufficient incriminating material is there. Paragraph. The trial is progressing and it cannot be said that there is delay in that regard. Paragraph. We are therefore not inclined to allow the petitioner's prayer for bail, at this stage, keeping in mind that if convicted, the petitioner shall attract a mandatory punishment of life imprisonment. This next dismiss kore daw, next follows. Since the petitioner is in custody for quite some time, we direct the learned trial court to expedite the trial to the fullest extent possible and conclude the same on an early date.
I'm grateful.
Case 45 fixed matter 1182 to 184.
Which one is this? Oh, yes.
On account of change of scope.
Thank you.
There are other ways.
Mr. Righty, you'll keep us busy till recess?
Yes.
Yes. Have some mercy on us. From 2 p.m. again. From 2 p.m.
Other matter.
Judgment
That has been adjourned.
3:45 there is a matter today. Yes, it will be. If Mr. Mukherjee is appearing, it will be adjourned.
আর এটা কই আর অন্যগুলো কোথায়
এই জহর এটা আমি কিছু লিখছিলাম না বলে এটা দাদা
অন্যগুলো জাজমেন্ট গুলো
ঠিক আছে
অন্য জাজমেন্ট গুলো
ভালো খবর
এটা করলাম প্রদীপ রাম ছাড়াও তো আছে কোনটা ক্ষতিপূরণ ছাড়াও তো আছে। ওইটা তো পুরোটাই কমপ্লিট না, এইটাই দিন।
Not ready.
Yes. Strongly. Passover Matter in ED court. That evidence is taken up. Now, my lord, Procedural Matter in the ED court. My lord, on the last occasion, my lord, your lordships, my lord, were pleased to ask me, my lord, one question, my lord, whether any application for cancellation of bail, my lord, was filed or not, my lord. My lord, my answer is, my lord, that, my lord, that application for cancellation was, my lord, filed by the state authority, state agency, when we did not even took up the investigation of the case. My lord, although, my lord, not on the ground of, my lord, that, my lord, defects or, my lord, because the state
Fraud practice.
no, my lord, not on that ground, because they because my lord, they, my lord, my submission, faith and substance of my submission before your lordship.
You are saying that fraud has been practiced.
Yes, my lord, and I have made some submissions, my lord, the some circumstances, my lord, underlying circumstances wherefrom it will be gathered. The lordships can very well gather the, my lord, the fact that actually fraud were practiced, my lord, for the purpose of facilitating, my lord, the bail grant of bail, my lord, by the to the, my lord, accused persons, my lord, the just by keeping the, my lord, 167 subsection 2 as a, my lord, sealed for the purpose of, my lord, granting them bail, my lord. So, my lord, the perpetration of fraud was practiced by the state agency for the purpose of facilitating bail to the accused persons. This was my submission. So naturally, my lord, this comes arises, my lord, they will not pray for.
I don't want to interject my learned senior friend.
এই তো
But
কথা হলো
only
senior
issue is that,
counsel।
my lord, I have never argued so for the fraud issue. My only
No,
point
question
is that
doesn't
there was
arise.
no
We will
notice to
argue.
me.
We will
No,
argue.
bail was that's
He
the
is
solitary point, my lord, I
yes,
have.
my learned friend. Now he is now designated senior, my lord. I think, my lord, he knows better than me, my lord, how to, when to interrupt, when not to interrupt, my lord. I am sorry, my lord, to say though. My lord, point is this, my lord, that my learned friend is, my lord, asking for, my lord, relief, my lord, that he who was granted statutory bail under the provisions of 167 subsection 2 CRPC, and that too was, my lord, cancelled by the NIA special court, my lord, when he came up before the honorable court, for, my lord, remaining on the same bail, my lord, which was granted bail bond, which he was on the bail that, my lord, that was granted, my lord, that statutory bail was granted, my lord, under section 167 subsection 2, my lord. The lordships were pleased to also ask me one question, my lord, that how they can come to learn that this investigation has been transferred to the NIA, my lord. My respectful submission before your lordship was to that, my lord, that, my lord, notice was issued from the court to appear, my lord. They did not appear, my lord. Then, my lord, order was passed by the special court, my lord, directing the surety, my lord, for production of the, my lord, the accused persons, my lord. Under that circumstances, my lord, when this order was passed by the special court, my lord, they came up before this honorable court before filing the cancellation application by the, my lord, NIA, my lord, they filed an application to continue in the same bail. That is to on the same bail bond or same bail, whatever may be the, according to who asked, my lord, which according to us, my lord, was, my lord, obtained by perpetrating fraud in collusion with the state agency, my lord. That's why, my lord, I underlaid some circumstances, my lord, wherefrom it will be gathered that fraud was practiced for the purpose of facilitating bail to the, my lord, others, my lord. Because, my lord, that charge sheet, my lord, which was to be filed, my lord, within 90 days, my lord, before one day, my lord, it was signed, charge sheet was made ready, but on the date when on the last date, my lord, when the statutory bail was going to be over, my lord, charge sheet was not filed, nor any application was made for, my lord, any time, my lord, for the time to file the charge sheet, my lord, that bail was granted before 2, and, my lord, bail bond was submitted, my lord, that is by 4:30, and 5:20, my lord, PM, my lord, that, my lord, charge sheet was filed on the last day when the statutory bail was going to, they obtained the statutory bail, my lord. These are the facts, my lord, which, my lord, shows, my lord, fraud was practiced, my lord, that trade agency was a party for perpetrating fraud, and for the purpose of facilitating bail, my lord, to the, my lord, accused persons, my lord, they, my lord, obtain bail.
My question is that if fraud is practiced upon a court, that court should consider.
Yes, my lord.
But there is no such
My
application.
lord,
from
even the, my lord, even the, my lord, the PP did not, even the, my lord, PP, my lord, even the PP who was appearing, my lord, he did not point out the charge sheet is otherwise made ready. Learned code also, my lord.
At this stage, can we consider that the fraud has been practiced upon this?
Because now, my lord, now their allegation against the learned, my lord, special court that I obtained the statutory bail that was cancelled. It is not cancellation simpliciter. It was, my lord, when they did not appear in spite of notice, COT was directed to produce the accused persons, my lord. Under that circumstances, in such a situation, my lord, they made an application to continue on the same bail which was obtained prior to, my lord, filing of the charge sheet, my lord. And, my lord, after filing of the charge sheet, my lord, in the charge sheet, even, my lord, some sections, my lord, of that is
judge has the right or authority under the law that to say that fraud has been practiced upon the
sessions
under which court, under which provisions of
Milord,
law, under which judicial decision.
Milord, special court, Milord, I will come to that order. The special court, Milord, consider all the aspects of the matter because your lordship was asking, Milord, whether cancellation was filed by the not. Cancellation was filed, Milord, after, Milord, bail was granted, Milord, bail bond was submitted, Milord, on, Milord, 5/8/2023, Milord. Now the cancellation prayer was made by the police, Milord, on 15th.
Not on a different ground.
On a different ground. On a different ground. Because the police state agency will not do. Because
but you could have.
At that time. At that time, we did not have the power, Milord. We did not take up the investigation, Milord.
After getting in,
Milord, may I submit, Milord? May I submit, Milord? That code, Milord, I am submitting, Milord. That was on a different ground. So, Milord, when the, Milord, this notice was issued, COT was directed to produce them. He, Milord, came up with an application to continue in the same bail, that interim bail. That application was being heard. On that application, Milord, there are judgments. I am citing those judgments. Whether, Milord, the court can cancel your lordship's, Milord. I am answering your lordship's query, Milord. Whether the special court, Milord, under the NIA Act or exercising jurisdiction, where can cancel that bail or not.
Mr. Maiti, more than that, the question is whether an opportunity was given to them.
Yes.
No, please.
My lord.
We'll start interrupting you whenever makes sense.
I'm sorry, Milord.
Whether an opportunity was given to them to deal with the proposal of the court to cancel the bail. Argument was made on one plank, on one point. And in the order, he goes and cancels the bail. Did he get an opportunity to tell the court that why my bail should not be cancelled?
No, he should be given an opportunity that you have practiced fraud to obtain the statutory bail. You deal with this issue. Where is that notice or something like that?
Milord, this is an argument on a question of law, Milord. It's a question before the law because when they are claiming any benefit on the basis of the statutory bail, Milord, under what the circumstances it was done, Milord, I am just submitting, Milord. Now, Milord, investigation, Milord, investigation was also made on that point, Milord. Now, kindly, Milord, I am going to, Milord, after, Milord, answering your lordship's query, Milord, I am going to refer some judgments, Milord, where your lordships, I will demonstrate, Milord, that the special court has the power upon, Milord, addition of grievous charges, Milord, or, Milord, some other charges, Milord, the court can suo motu. Also, Milord, they were the given opportunity, Milord, because their application, Milord, they were given opportunity to hear. We also made our submission in fullest way, Milord. That will also be apparent from the order which was, Milord, passed by the learned special court, Milord. It will appear, Milord, that full-fledged hearing was made, Milord. Now, let us come to the point, Milord, whether first question, Milord, that, Milord, hey,
answer to Devin, answer. What do you have to say?
Because merits were ready data.
I'm giving you lots of square, Milord. I know, Milord. That is, Milord.
We are considering every aspect.
Yes, Milord. Yes, Milord. Definitely, Milord. We'll expect that also, Milord. Milord, I am referring to a judgment, Milord. That is, Milord, 2019-17 SCC 326.
2019.
2019 7 SCC 17 SCC 326, Milord.
17.
Yes, Milord.
26.
326.
326, Milord. Prodipram. Prodipram versus State of Jharkhand. Now, Milord, the proposition is, Milord, whether in a case where an accused has been bailed out in a criminal case, in which case subsequently new offences are added, it is necessary that the bail earlier granted should be cancelled for taking the accused in custody. The point is, Milord, on that point, Milord, arguing, Milord, what precisely Milord failed from Lordship with the bow down to your Lordship, Milord, asking this very, very valid question to me, Milord, that whether, Milord, that can be done or not. This will be, Milord, the judgment which I am citing, Milord, subject to your Lordship's, Milord, consideration or approval, Milord. Kindly consider, Milord, that whether in a case where the accused has been bailed out in a criminal case, in which case subsequently new offences are added, is it necessary that the bail earlier granted should be cancelled for taking the accused in custody or not? Kindly have a, Milord. So, Milord, here, Milord, when the charge sheet was, Milord, submitted by the before filing of the charge sheet, Milord, some sections were there. I have shown to your Lordship, Milord, on the last occasion, Milord. I am repeating because it will, Milord, be of consuming time, Milord. So, Milord, that sections were not there. Chiruka Water Cities Act, Milord, we have filed, Milord. And, Milord, section 3 and 4 and 5, Milord, that are of the, Milord, Explosive Substances Act are there, Milord, that have been added, Milord. If this is the situation, Milord, because this was a, Milord, your Lordship, FIR simpliciter, because no charge sheet was there when the statutory bail was granted. Now, Milord, while we, Milord, made the investigation, after taking over the investigation, we'll file the charge sheet, Milord. Before that, we did not have any jurisdiction or, Milord, power or any occasion to file any application for cancellation of bail. Even if it has not been done, whether the Prodipram is a complete answer will be supported by another judgment I will refer to your Lordship, Milord. Paragraph 31. Paragraph 31, page. Yes. Milord, kindly have a look at page 344. In view of the following discussion, we arrive at the following discussion in respect of the circumstances where after grant of bail to an accused. Milord, even, Milord, we are forgetting about the statutory bail, Milord. Even the regular bail was granted, Milord. What may be the consequences? In such a situation where, Milord, I have, Milord, just demonstrated, Milord, the accused can surrender and apply for bail newly added cognizable and non-bailable offences. In event of refusal of bail, the accused can certainly be arrested. And clause, Milord, paragraph, Milord, clause, Milord, 31.2, Milord, in Prodipram case, Milord, 342. Then, Milord, the investigating agency can seek order from the court under section 437.5 or 439.2 CRPC for arrest of the accused and his custody. And the court, in exercise of power under section 437.5 or 439.2 CRPC, can direct for taking into custody the accused who has already been granted bail after cancellation of bail. The court, in exercise of power under section 437.5 as well as section 439.2, can direct the person who has already been granted bail to be arrested and commit him to custody in addition to graver or non-bailable offences which may not be necessary always with order of cancelling of earlier bail.
Notice is not required. Is there any mention?
Milord,
My
Milord,
conception is that he must be given a notice.
Yes, Milord. Now, Milord, this is Milord, in this situation, no notice is required even.
Notice is required.
No notice has been, Milord.
Why is that?
31.4, also read
31.4.
31.4.
In case where an accused has already been granted bail, the investigating authority on addition of an offense or offenses may not proceed to arrest the accused, but for arresting the accused on such accused on such or addition of offense or offenses, it needs to obtain an order against the accused from the court which has granted bail for fresh arrest, my lord. Now, point is, my lord, next, my lord, whether registration of FIR so and so is a second FIR or is not permissible, being already an FIR number so and so registered by the police at so and so police station out of the same. Subsection 6 of Section 6 prohibits the state government or any police officer of the state government to proceed with the investigation. My lord, the moment, my lord, we start investigation, my lord, police cannot. Before that, police has the authority to investigate the case, my lord. Now, my lord, the subsection 6 of Section 6 prohibits the state government. Para 45, my lord, kindly have a look at para 45, my lord. Para 45. So, my lord, next point, my lord. Non-mention of the provisions does not make the law inconsequential. Paragraph 67. The special judge in his order has neither referred to Section 309 or Section 167 under which the accused was remanded when the court has power to pass a particular order. Non-mention of the provisions of law, wrong mention provisions of law is not is inconsequential. As held above, the special judge could have only exercised power under Section 3092. Hence, the remand order dated 25/6/1 has to be treated as remand order under Section 309. The special judge being the empowered to remand the accused under Section 3092 in the facts of the present case, there is no illegality in the remand order so and so, so and so. Now, the question of fraud. My lord, this judgment, my lord, before coming to that, my lord, this judgment, my lord, finds place, my lord, support, my lord, in a judgment, my lord, reported in, my lord, 2025 SCC, page 1. Sushila Agarwal versus State, NCT of Delhi, Sushila Agarwal versus State, NCT of Delhi, 2025 SCC 1. Now the question here arises, my lord, whether the accused has to apply for fresh bail after graver sections have been added to the charge sheet. Therefore, my lord, now, my lord, after obtaining the bail, my lord, state filed the charge sheet, my lord. Whatever may this file the charge sheet, my lord. Now, para 79, page number 102, the view that this code expresses about prosecution's option to apply for election to arrest the accused finds support in Pradeep Ram's case, where this code held as follows. Because that sections have been quoted, Pradeep Ram's judgment has been relied on, whether even without cancelling the bail granted to an accused on relevant consideration, the court can direct the accused to be arrested and committed to custody. But here the extreme point, my lord, was considered, my lord. In Sushila Agarwal's case, my lord, para 21, my lord. Yes. Paras 23, 27, 29, 31. This is judgment. Page mirror 342, 345. Paragraphs 23, 27, 29, and 31.
Which previous decision?
No, my lord, that was, my lord, reiterated in the latest judgment, my lord. That is the, my lord, that was 19. Now this is, my lord, 20th, my lord. The principle which was adopted, my lord, whether can, even without cancelling the bail granted to an accused on relevant consideration, the court can direct the accused to be arrested and committed to custody. The extreme case, my lord. Extreme, my lord, step can be taken by the court, my lord. paragraph 23. The literal meaning of the word bail is surety. The council referred to in the meaning of bail in Holsbury's Laws of England, so and so, volume so, and submitted that it is aimed at placing the accused in custody of his sureties, who are bound to produce him to appear at his trial. Lord, here, my lord, immediately after, my lord, it was transferred to the NIA. Special court took over the jurisdiction, my lord, to have the power to do this, my lord. Then, my lord, notice was issued. The accused person did not respond to this notice. Because when the, my lord, this court has, my lord, your lordship, my lord, kindly consider, my lord, when the, my lord, investigation has been transferred to another agency, my lord, like NIA or CBI, my lord, the earlier court, which has a jurisdiction, itself loses its jurisdiction. When the, my lord, records are transferred, when the investigation is taken over, and this court power is assumed by the special court, the power of the, as a general court, the power of the original court ceases to exist, my lord. So what they could have done, my lord, in the circumstances, my lord, when the notice was issued, my lord, that you are required to appear before the court. So opportunity was given. They could have appeared before the court and prayed for fresh bail. Or instead of doing that, they did not respond to it. Then, my lord, another order was passed to give them opportunity, my lord, give a caution, my lord, that if you do not come, now the court which granted the earlier bill did not have any jurisdiction to do that. We can cancel it. That's why, my lord, that notice was issued to the surety by passing order by the special court that if you produce the accused persons, otherwise the bail will be cancelled. Thereafter, my lord, after that, my lord, when the
Produce, bail will not be cancelled.
My lord, no.
Produce, otherwise bail will be cancelled. Produce the.
My lord, generally it is done. My lord, generally it is done.
Then if produced, the bail will not be cancelled.
No, that is the point, whether it can be cancelled or not. Whether it can be cancelled or not. They wanted to, my lord, continue on the same bail which was granted by the court, which now did not have the jurisdiction to, my lord. Here, my lord, this is another thing. My lord. Kindly, my lord, may I make myself clear, my lord. When the same court is continuing with the jurisdiction, my lord, the case is different. When the, my lord, court of original jurisdiction has lost its force, my lord, lost its power, then, my lord, transferred to some other agency, my lord, then special court does have the jurisdiction, my lord, to do anything or to undo anything. My lord, now the question is whether your lordship's query was, my lord, whether opportunity was given to him or not. My lord, opportunity was given. He was asked to appear because that sufficient notice was to them that now the order investigation has been transferred to the NIA.
The investigation is transferred, case is transferred to this court. We may cancel your bail, or you have.
No, my lord, he is to appear, my lord. When automatically, my lord, if any court, if any investigation or if any, my lord, case is transferred to the, my lord, special court, my lord, automatically the power of the original court ceases, my lord. Had it had been no, not in a bail in cancel, then I will have to come again to, my lord, read the whole, my lord, order, my lord, whether sufficient opportunity was there or not. He did not. He did have the opportunity. They did have the opportunity to go to, my lord, argue their case in a fullest form or not. So, my lord, under, my lord, case is different, my lord. If, my lord, original bail has been granted,
empty slot. Whose slot is empty?
my lord, I was just trying to, my lord, distinguish subject to lordship approval in
Mr.
two
Maiti,
different.
how much more time will you take? Because
Lord, I will, my lord, submit.
today is the third day we are hearing you.
Lord,
as recorded in our orders.
Lord, I was trying to do it as fast as possible.
No, tell us.
Because
how,
in
no,
other,
because just tell us how much more time you will take.
court of judgment আমাদের আছে দেখো, right. At least 6 more judgments are there, and also four. And submission then, Milord, at least 45 hours, 45 minutes. 45 minutes, Milord.
Please
I'll
ensure
complete.
that you end or conclude within 45 minutes.
Yes, I'll complete it. Because I am trying to, Milord, demonstrate before Lordship two phenomena. Number one, original code, Milord, granted interim bail. Whether can be cancelled.
Next Tuesday.
Tuesday কত তারিখ হচ্ছে?
Mr. Maiti,
Milord, Tuesday, Milord, only one thing, Milord. I have to go to the, Milord. I should not say this, Milord, before this court, Milord, that I will go to, Milord, learned court below. Milord, here in a special PP, that's why I have to conduct a consideration of charges there, Milord. So accepting Milord, Tuesday on any day, Milord, 22nd, because I do not know how much time they will be taken, Milord. 22nd, no problem. 22nd.
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 Mr. Maiti, learned counsel representing NIA resumes his argument but does not conclude. Paragraph as requested, let this matter be listed again for further hearing on January 22, 2025, marked 12:45 p.m.
If your Lordship, Milord, shows things, Milord, but that is, Milord, all right, Milord. In our cases, Milord, that even we can, Milord, after 4:30 we can continue the argument without disturbing, Milord, if your Lordship's, Milord, so permits, Milord.
And who will do the administrative jobs that we are required to do?
That is the problem. That is the problem. The problem.
তাহাতে নিয়ে যান স্যার। আচ্ছা ওদেরকে দেওয়ার জন্য একটা হবে।
36, my lord. Last occasion, your lordship directed the learned my lord in charge to file a report regarding the delay and also on the merit.
Not
Petitioner is in
delay.
custody. Petitioner is in custody for 5 years. Yes, under section 302. My lord, total 18 witnesses were examined. My lord, out of 35 witnesses. My lord, I prepared one chart.
All of that what you said is recorded in order.
Absolutely.
No, my lord. I made a chart, my lord.
You did not mention it, the fifth application.
Let him complete. Otherwise, my lord, your lordship will not be able to pass the order, nor I will be able to submit.
Renewing my prayer, my lord. My lord, my prayer was lastly rejected.
What chart is that?
My lord, charge under section 302.
Chart, what is the?
The chart regarding, my lord, the base allegation against me by the 17 witnesses.
Let the state say so.
My lord.
My lord, this is the report. My lord, last rejection was on February 2024 when 7 witnesses were examined. Now, my lord, we have examined 18 witnesses. The next schedule is further 4 witnesses out of 35. My lord, most of the witnesses, how fast we can, my lord, how expeditiously it can be, my lord, trial court.
Evidence against him, incriminating evidence.
My lord, this is the 5th application.
Incriminating
This is the 5th application. So, my lord, on merits it has already been. Now, my lord,
The witness, my lord, I produced, my lord, all the witnesses by supplementary evidence.
There is no eyewitness.
No.
No. There is no eyewitness, but the eyewitness who were present before disposing of the body, it was their 164 statement implicating that. No doubt about it. There is no direct eyewitness.
See, one has to balance all
After
the
your
factors.
lordship's rejections, my lord, in this honorable court in February 2024, 7 witnesses were examined. That was the 4th application. We have now examined, my lord, 18 witnesses.
My lord, kindly give. My lord,
So, my lord, the delay part, my lord, subject to correction by your lordship, my lord, is.
yes.
My lord, we need some time. My lord, there is brutal.
What sometime you have mentioned in the report 1 year.
That's sometime, my lord, that's your lordship. Your lordship give me directions, my lord, within 6.
We
7.
cannot. You know that very well. Why do you say
That's why,
this?
my lord, out of February, my lord, we have examined 18 witnesses. When your lordship has recorded in the order, my lord, 7 witnesses were there.
Initially, you were lagging. Initially, you were responsible for.
Responsible.
5 years.
231 application
Within
was.
1 year, you have been able to complete.
No, that's why. That I'm not saying, my lord. But after last rejection, the 4th application, my lord, we have expeditiously proved. We have improved.
Issue. Status report filed by the state be kept with the records.
The case of circumstantial evidence.
Circumstantial evidence, my lord, the evidence is.
Paragraph. The petitioner is in custody for more than 5 years. Stop. 17 out of 18 out of 35 charge sheet named witnesses have been examined. Stop.
Schedule is fixed on 10th and 11th.
Learned state advocate says that the next schedule is fixed on
10 and 11 of February, my lord. Further
February
4
10 and
witnesses.
11. February 10 and 11, 2025. Stop. He says that although there may not be any direct evidence, there is strong circumstantial evidence against this petitioner. Stop. He vehemently opposes the prayer for bail. So paragraph. 5 years is far too long a period of time to keep an under trial in incarceration. Stop. We have said on many occasions that the prosecution may have an iron cast case to secure the conviction of the accused person. Stop. That per se, will not justify keeping the accused person in incarceration for an indefinitely long period of time without taking the trial to its logical conclusion. Stop. Paragraph. Although the report filed by the state mentions that the trial is likely to conclude within 1 year, approximately, subject to trial court's diary permission, unquote, comma, we are not convinced by such a statement. Stop. By going by the past conduct of the trial, comma, we do not see that the trial is likely to end in the near future. Paragraph. Without touching the merits of the case and solely on the touchstone of Article 21 of the Constitution of India, we feel constrained to allow the petitioner's prayer for bail.
It shall remain within the jurisdiction of English Bazaar Police Station and shall meet the IC English Bazaar Police Station.
Chachol, my lord.
I know that.
Oh, English Bazaar.
I do not allow you to enter Chachol.
Absolutely.
Yeah, apply your mind.
My lord.
You thought that I mistake.
No, no. Sorry, my lord.
Always you are.
No, no, no. Sorry. Ena.
Deeply.
Additional session judge Chachol, Malda.
After getting well, you did not say anything.
Your Lordship, I'm praying for not this weekend. Passover.
My Lord, I am for the petitioner. I'm for the petitioner. The petitioner is in custody for 12 years, almost 8 months, few days left. The case is, now it is fixed for argument. No, no.
My lord, case is at its fag end,
The
my lord.
the court is the court is
Examination
like-
under section
Allow me
313
to
has.
finish first.
My lord.
Yes.
The court is fixed for argument. The court is lying vacant since long. They are in custody for last 12 years, almost 8 months, few days left to complete the 8 months. But I'm praying for an interim bill. I've got a very good case to defend myself. I'm not on that.
Then show us the deposition that you will.
Or 302, 302.
302.
You have arguable case.
Any eyewitness?
Yes, my
Yes, they say that they have eyewitnesses.
They say.
several eyewitnesses are there, my lord.
They say
But
that they have.
show us what have they said in the evidence, Mr.
My lord,
Chatterjee.
I don't have the evidence. This is statement 161 statement, my lord.
161 statement.
My lord,
That's
my lord,
true.
I'll
My
tell
lord,
you.
one more.
Let us peruse the deposition.
Yes.
My lord, kindly.
I'll tell you, Lordship, in a nutshell, because I am there in the trial court. I know how is it going on.
Sir, let the state counsel go through the deposition, indicate to us this Friday only. We'll keep it on Friday.
Right. My lord, then kindly fix it up at 3:30. It will take some time because if he,
We can't fix up a time. Can't
why
fix
I
up.
say this, because if he wants to go through the deposition, I'll have to show your Lordship where the latches, the lacunas on the part of the
No,
person.
we are not, sir, please, we are not going to analyze the evidence. Prima facie, we'll just see if the witnesses have implicated you. That is all.
That is true, my lord. So far as
No 330, question of 330. You have got copies of deposition now. Go through it, mark the portions that implicate his client, if at all. Come back on Friday.
My lord, in this case, my lord.
Among the first day, I think.
Amongst the first day.
My lord, with this item, my lord, item number 378,
Sir, I
that
am
is
appealing
with
for the
respect of
petition
another
378.
co-accused man.
Similar.
My lord, can be
Same
dealt
matter.
You are
together.
waiting for.
Johor, you are also in custody for 12 years.
More than that.
more than 12 years.
12, more than 12 and a half.
Hey, 378 টা এটা ঠিক পরে লাগিয়ে দেবে।
Rejection.
For my case,
Look, for
2012, there was a rejection.
even in my case,
Thereafter, my lord.
the second time,
2012
2012.
we just-
12 বছর
My lord, there was a
More than 12 and a half
My
years.
lord,
your lordships will
My lord-
kindly appreciate that there was an inordinate delay in
লেখো
On
লেখো
interim bail, my lord, we are praying, sir, that
On Friday, we'll either grant or not grant.
My lord.
Let them go through the
My
deposition.
lord. So you are saying that there are sufficient material?
Yes, my lord.
Okay.
My lord, one application under section 408 of the Criminal Procedure Code was filed by the prosecution. There, the accused objected, my lord. Kindly see the order.
No, just.
For that reason, court was not
Oh, yes.
transferred. At what stage, sir? My lord, this is the order.
I know that what
Now they are
exactly is
paying.
it.
He is the resident of Uttar Pradesh.
No, all of them are resident of Garden Ridge. Iqbalpur.
Come back on Friday, we'll. The petitioner.
One thing, my lord. Allow us to complete, then your case. This is not your case.
The petitioner complains and somewhat justifiably complains, comma, and somewhat justifiably, comma, that he is in custody for 12 and a half years.
12 years, 8 months almost.
For almost 12 years, 8 months. Stop. The trial is still going on. Stop. He prays for interim bail.
My lord, it's 12 years, 8 months. I'm sorry.
For 12 years, 8 months. Paragraph. Copies of depositions of the witnesses who have been examined before the learned trial court have been made available to learned state advocates. Stop. Learned state advocates are requested to scan the evidence and point out to us, comma, to what extent, comma, if at all, comma, the witnesses implicate this petitioner.
Case is pending for argument.
Stop.
Argument is going on.
No.
Yes, my lord.
He is in the trial court. He is saying no, and you say yes. Are you appearing in the trial court?
We started afresh.
Your instructions are 50% wrong. We have found.
Only you.
Yes.
The argument has to be started afresh.
Uh,
New court then.
next date, you know when?
18th.
18th January.
January.
The court is lying vacant. It will not be taken.
না, ব্যাস, দরকার নেই বলার। This the matter once again. A Friday, date দাও, amongst the first 5 items.
Grateful.
Along with my lord,
12 years, 8 months, Mr. Ganguly.
My lord,
You know what is passing through our mind. Whatever there is in the evidence. Convict him, hang him. We are.
we have not in the way. My lord, the court was vacant.
Not their fault.
This
I just seek an indulgence. They will refer to whatever number of witnesses. I don't mind. I will simply refer to evidence of the postmortem doctor.
it was objected by the accused.
It's
Next was objected by them.
Dakho.
Grateful, my lord.
আচ্ছা, ওটা বলে দাও, let CRM be listed. Give your number.
378.
item number টা কত?
Item number 378.
Item না। হ্যাঁ,
Four
সেটা
one,
রেকর্ড
four
করে
one.
দাও অর্ডারে। হ্যাঁ, be listed immediately after this matter.
নামটা দিয়ে দাও না।
ঠিক আছে। এর সাথে ওটা ট্যাগ করে দাও। ও সেকেন্ড
Item 42, 42.
ঠিকই রাখবেন।
41, Madam, Mr. Mukherjee is leading me this.
Tell us, not this week, not today, not this month, not this year.
Not today.
Not today.
Which one?
My lord,
40, 41, 42.
40, 42. 43, 42.
He is appearing in 41. Now, since
But
this
I'll be representing from 40 to 42.
and I'm for the deputy complaint, my lord, led by Mr. Vikas Ranjan Bhattacharya in all the matters.
Huh?
40 to 42. I am.
Yes, what?
No, Lordship, for the deputy complaint.
Cholo.
Well,
Not
41
today.
maybe not this week, man.
Huh?
41 man, not this week.
Well, the action.
All together, yeah, all not this week then.
Not this week, man. Great.
It's for 40 is also very important. Item 43.
একটা কেসে যদি বিশ্বাস করতে পারো
Petitioner, my lord. My lord, on the earlier occasion, my lord was pleased to direct the petitioner, my lord, to present the order by the learned trial court judge, my lord.
My lord, he has not.
Yes, my lord.
Order of bail of the court.
And my lord, I have brought the order, my lord.
He was granted bail by trial court.
Yes, my lord.
Then he jumped the bail.
Then he jumped the bail.
Again arrested.
Again.
Yes, my lord.
Arrested or surrendered?
My lord surrendered, my lord. Surrendered.
Why did you jump bail?
My lord, I was not informed by the learned advocate below, my lord, about the date, my lord. That's the reason.
When was bail granted?
12th
My lord.
April 2020.
Yes, my lord. 12th April 2023, my lord.
That was an interim bail.
Yes, my lord. Interim bail.
That was not even confirmed.
No.
AI bail.
AI bail. That means you have to appear on the next day.
Yes, my lord.
Then no ground.
No, interim bail was granted, madam, when?
On 12th
2023.
23. When he surrendered again?
My lord, on 6/8.
When did you surrender? Where have you written that?
4/9/2024, my lord.
Whatever it was, examination was going on.
Yes, my lord.
During that time, you absconded.
No, my lord. No, not absconding, my lord.
Not appearing.
Yes, my lord.
Not appearing.
Not appear.
Okay.
My lord, because the date was not communicated, my lord.
Learned advocate Sri Manoj Kumar Shah representing accused Rajiv Biswas submitted that since the accused was not making any contact with him since long, he would not take any steps on his. He prayed for passing necessary order.
You did not get in touch with your lawyer. This is as good as absconding.
But my lord, I surrendered before the learned court, my lord.
Of the evidence of PW1 recorded transfer there is sufficient materials against the accused. So in order to dilate the situation, you absconded.
302. What is
But
the
my
extent
lord,
of
all
implication?
other co-accused are, my lord, on bail, my lord. Please consider it this
The
one.
merits have not gone into my.
Are on bail, my lord.
Please with you.
They absconded.
Only not today.
Trial has started.
Evidence is going on next date.
My lord, I have not absconded, my lord. I've surrendered, my lord.
Why you did not appear? That means that you absconded.
My lord, the date was not communicated, my lord.
He was absconding. When the charge sheet was filed, he was absconding.
সেপ্টেম্বর থেকে তো এখন আছে জেলে না তো কয়েক মাস ডিসমিস করে দাও
The petitioner claims that as the learned counsel, the trial court did not intimate him, he was unable to appear before the learned trial court on certain dates, and subsequently warrant of arrest was issued, and before his arrest he surrendered before the learned trial court. However, his bail prayer was rejected and he was taken into custody. He has been languishing in the judicial custody since September 2024. If the petitioner is enlarged on bail, he shall comply with the conditions that imposed upon him, as will be imposed upon him. Stop. Para. The learned counsel for the state opposes the prayer for bail. The petitioner is in the habit of absconsion. Stop. Previously, he absconded and subsequently he was enlarged on bail. But when the examination of the prosecution witnesses was going on, he again disappeared and remained absconder for a considerable period of time. Stop. If the petitioner is enlarged on bail, prosecution may suffer. Stop. Para. We have considered the materials on record.
My lord, for only one date, my lord.
And we find that the petitioner did not appear before the learned trial court when he was on interim bail. Considering the attitude and conduct of the present petitioner, we are not inclined to allow the prayer for bail of the petitioner at this stage.
when he was on interim bail আগে সেন্টেন্স তারপরে একটা অ্যাড করো We further find from the learned trial court's order dated to পড়লে একটু আগে that it such and such that the petitioner also did not keep in touch with his learned lawyer who represented him before the learned trial court. এটা বলে দাও dated order.
Order number 6, dated 4/9/2024.
হ্যাঁ February, ওকে এখানে রেখে দেবো অ্যারেস্ট করতে হবে অ্যারেস্ট করতে হবে
My Lord, I am for the petition. My Lord, it's a case under 300 to 34 of the Indian Penal Code, my Lord. My Lord, petitioner is in custody for 301 days, almost 10 months, my Lord. My Lord, incident is that, my Lord, due to previous enmity over a long-term land dispute, the de facto complainant's son was assaulted by a group of persons who are the co-villagers, my Lord, and later he succumbed to his injuries. My Lord, 12 persons were specifically named in the FIR, but the name of the petitioner was not in the FIR. He is not an FIR named person. What happened? Several 161 statements, as including the statements of the de facto complainant and the eyewitnesses, had been recorded, wherein, my Lord, no name of the petitioner was taken. My Lord, name of the one Selim Sheikh was taken in the 161 statement. He has been granted anticipatory bail by a coordinate bench of this High Court. My Lord, that is appearing in the petition, page 7. My Lord.
On what basis were you implicated? Tell us that.
My Lord. Later, my Lord, subsequent to that, my Lord, the de facto complainant made a statement that I made a mistake. My father's name was inadvertently written in the FIR. It will be, my name will be, my father's name will be replaced by me. And on the basis of that, I have been implicated in this case. Charge sheet has been filed. My Lord, one Selim Mondal has been granted anticipatory bail. His name has been taken by all the, my Lord, all the witnesses who recorded their statement under 161, my Lord. And my Lord, another person, my Lord, namely Shahadal Mandal, who is FIR named, he was also been granted bail. Okay.
Yes.
My Lord, FIR.
Kamal Sheikh.
Can you please see the 164 statement? There I have underscored.
Yes.
There is Kamal Sheikh. Before that, Ansar Sheikh is named. Ansar Sheikh is the father of this Kamal Sheikh. For the first time in the 164 statement of the de facto complainant who claims to be an eyewitness of that incident, Kamal Sheikh has been introduced instead of Ansar Sheikh. But considering the fact, my Lord, that 164 statement, that Selim Mondal has been granted bail. At that time, my Lord, the coordinate bench of this Honorable Court considered that 164 statement and came to the conclusion that since Selim Mondal is not named in the 164 statement, so his welfare may be considered. But here, once Kamal Sheikh is named, and at the end of the charge sheet, police also said that Ansar Sheikh was replaced by the Kamal Sheikh, as it was subsequently informed by the de facto complainant. It is also there.
So, what about other accused persons who are named in the 164?
My Lord,
where they are granted bail?
One Shahadul Mondal has been granted bail.
Why?
Shahadul.
I saw Thaki was being assaulted with sarcastic weapons. Akramul Mondal, Hossein Mondal,
these are the
Kamal Sheikh, son of Ancha, and many others. There's Shahadul's name was not here. That's why he was granted bail.
No, my lord,
If we grant Kamal Sheikh's bail prayer, then all will be.
my lord, kindly consider.
Say that will stand.
My lord, kindly hear me for a moment, my lord. My lord, in the 161 statements, my lord, all the eyewitnesses' statement was recorded. Only 164 has been given by the de facto complainant. The eyewitnesses has not, their 164 has not been.
Excepting the de facto complainant, there is no other eyewitness.
No, my lord, there are eyewitnesses are there, my lord. 161 is 207 copies are with me, my lord.
Consider 164.
So your lordship 161 statement of any eyewitness?
Yes,
my
you
lord.
cannot, how long you are in custody?
My lord, 310 months. My lord, kindly consider these statements of the eyewitness, my lord. He has implicated, my lord. He is the eyewitness. His statement was not recorded. Subsequent thought, this is a subsequent thought, my lord, after thought. He is a statement of eyewitness. Selim Mondal has been named. Shahadul has been named.
So Saad Ali will get bail by showing 164. You will get bail by showing 161. Saad Ali will get bail showing 164, and he will get bail by showing 161.
Kindly consider that those
I am
parts.
considering. When I am discussing with you, certainly we are
This is the fact, my lord, I have placed before lordship, my lord, kindly consider, my lord.
What is your submission?
Regarding one of the prayer of bail, I am opposing. Obviously, I am opposing. When Kamal Sheikh name has been introduced in 164 statement, and all the accused persons took advantage of 164 statement as their names are not there. That is number one. Number two, Kamal Sheikh's names is there. If that person is granted bail, as fell from your lordship, obviously that will happen. All other person will come and say 164. We are all similarly circumstanced.
Principal accused has been enlarged on bail since his name is not there in the FIR. Shahadul is the principal accused there. The dispute is.
He was the FIR first.
My lord.
First. Page number one.
He has named 12 persons. My name was missed. Subsequent afterthought, my name was introduced. 12 persons were named.
What is the stage of the?
My lord, commitment has been done. Charge has not been framed.
Kamal Sheikh's name is not here.
No, that is not answer Sheikh. Answer Sheikh. And answer Sheikh has been replaced for the first time in 164 statement by the de facto complainant, saying that I wrongly took name of answer Sheikh, that would be Kamal Sheikh. That is the entire scenario.
If he has committed mistake, then what can be done? But problem is that names transfer here and here. Kamal Sheikh's name is not here. We can distinguish.
Obviously, Kamal Sheikh's name is not there because Kamal Sheikh, instead of Kamal Sheikh, answer Sheikh's name has been given.
That used to be considered at the time of trial. But we can distinguish. The Kamal Sheikh's name is not here in the FIR. That can be done. And what is the mistake has been corrected where?
164.
164. Mistakenly stated where? This?
My lord, I will show his 161 also.
I am asking.
No, my lord.
Okay, 164. Page 58.
We are not inclined. Learned counsel for the petitioner has submitted that petitioner is in the custody for about 10 months. Stop. His name does not transfer in the FIR. In the FIR, de facto complainant has named the present petitioner at the time of recording his statement under section 164 CRS. Petitioner has been falsely implicated. However, considering his period of detention, he may be enlarged on bail on any condition. Stop. Para. So, we have considered. No, the learned counsel for the state has opposed this prayer for bail. According to him, the de facto complainant has committed a mistake at the time of lodging FIR. However, subsequently, he rectified his mistake and named the present petitioner along with others at the time of recording his statement under section 164 CRPC. Stop.
আর কি বলবো না
Ahad Ali has been named in the FIR. Why he has been granted bail? Ahad Ali has been named in the FIR.
Not in the 164 statement. That is kindly see the order of this coordinate bench of this honorable court. Only 164 statement has been relied on.
There are so many mistakes.
Mistakes, yes, I appreciate, my lord, I appreciate. Something confusing, something messed up. But we'll have to clear up.
এর নাম বাদ দেয় পার্সেলের নাম ধরে দেয় আর ট্রান্সফার হতে পার্সেলের নাম ধরে দেয়
Prosecution may suffer since other accused persons are absconding.
No. All are in, yeah.
All are not. Suffer a loss. Stop. Para. We have considered the materials on records. It appears that the petitioner along with others have been named by the de facto complainant at the time of recording of his statement. However, the name of the accused Saad Ali, who has been granted bail, was not taken by the de facto complainant at the time of recording his statement under section 164 CRPC. However, as there are sufficient incriminating materials against the present petitioner, we are not inclined to allow the prayer for bail of
The petitioner, my lord.
For the victim.
My lord, victim is dead. 302, my lord.
De facto,
No, de facto complainant is the police. He is the eyewitness, possibly one of the eyewitness.
Family, victim's family person.
No, not possible. Not even as well. Let him disclose who is appearing for.
Where is your wakalatnama?
We filed in the department. On possibly on behalf.
Why? Who has signed the wakalatnama?
Witness, one of the witnesses. Sonu Sahu.
Sonu Sahu, one of the witnesses.
Why did you say victim?
Oh, he was also a target.
302, my lord.
Target, my lord.
Well,
yes, tell us.
My lord, it's under 302 Arms Act, my lord. He is in custody for 3 years, 4 months, my lord. The trial, my lord, there are 18 witnesses, 12 have been 12th witness is going on. Deposition of 12th witnesses going on. Last date was on 10th January.
This is your renewal?
No. First time. I'm appearing. I'm
3 years, 6 months in custody.
3 years, 4 months, my lord.
Mr. Dotto, file a report.
I'm just giving you the status.
No, please don't file a report.
My lord, may I also?
No. We are calling for a report.
My lord, may I hand over a copy of the deposition? I will be relying on it
Give
on
it
the
to
next
Mr.
day.
Dotto. Can it go through it? Give one copy to this.
I'm one of the witnesses, sir.
Very well. You are one of the charge sheet named witnesses.
I have already deposed in this.
Oh.
Out of 18, my lord.
One of the co-accused, my lord, had appeared before.
With due respect, my lord, they cannot come up as opposed bail.
The petitioner says that he is in custody for about 3 years, 4 months. Stop. There is inordinate delay in the progress of the trial. In progress of the trial. That Stop. He prays for bail. Paragraph, let the state file a status report indicating, inter alia, how many witnesses have been examined so far and how many more witnesses the prosecution intends to examine. Stop.
Are you one of the victims?
Yes.
Then you can.
Yes,
My lord, victim.
My lord, I am.
No, please.
My lord, yes, sir.
If you one of the victims, you can. Even if you are an.
Yes, I am, my lord. I am
You can,
PW2.
otherwise
My
you cannot.
deposition is there.
Very well.
I was in the midst of the melee.
Stop.
Yes, I am. With confidence, my lord, I am.
Paragraph, copies of the depositions of the witnesses examined so far have been made over by learned advocate for the petitioner to learned state counsel. Stop. Learned state counsel shall go through the depositions and apprise us on the next date, to what extent the witnesses implicate this petitioner, if at all. Paragraph lists the matter. 22nd. 22nd. You also point out.
Yes. Mine is ready, man.
Now you show us first.
Absolutely,
then
absolutely,
we will hear you.
absolutely. Co-accused was already before your lordship. Co-accused was already before your lordship. Another application. They were forced to withdraw since implications were all there. He actually held the victim from the back.
Next.
Man was killed.
Time frame টা চাইছি।
At 48, I'm praying for a week's accommodation on behalf of Mr. Mukherjee.
Not this week. नहीं चलो। बांग्लादेशी नेशनल लो।
My lord, actually the petitioner before your lordships is a lady accused in the sense that it was alleged that she was having an affair with a distant relative. It is the allegation. Now, my lord, it is alleged that, further alleged that she was caught and by the husband in a, my lord, compromising position.
54 years. What is the age of the?
My lord, the victim is not very 30, around 35 years. Her age is written as 31, but she has got a married daughter of 21. Yes,
So
yes.
how is this petitioner and the victim related?
My lord, victim is her husband. It is alleged that she was having affair with somebody. The husband came back and found her involved with somebody who is the, my lord, distant relative of the husband and his wife. Now, the moment it was discovered, it is alleged that this person hit with a hammer and fled away. And this victim, this lady, wife of the victim, took her along with one of the witnesses to the hospital. And my lord, kindly have a look at the, my lord, medical reports, the bedded ticket, where I have found, my lord, that he has named that person only, not his wife, as the assailant. I beg to rely upon that. I am in custody since the date of arrest, and my lord, one hammer has been shown to have
Victim
been.
statement was recorded.
Yes, my lord.
Before he passed away.
I do not have such whether any dying declaration was recorded. Yes, my lord. That is perhaps in the city. My lord, that is must be in the city, my lord. Let them produce because
not present, my lord. Then, my lord, I will have to.
Not dying declaration. He has a history of assault or something
Yes.
like that recorded by the doctor.
Yeah, I'm grateful.
Initial
My lord.
stage.
I'm
My lord, the inquest
In the inquest report, her name is transpiring as an
Yes,
accused.
yes.
In the one,
How in inquest making inquest officer name the
no,
My lord,
I want to say that from the very beginning, her name is transpiring as an accused, not as a witness. My lord, she along with that person, my lord, there are 161 statements who are neighbors who have stated that immediately after the incident they reached there, and my lord, that lady was there, the paramour was also there, and my lord, the hammer was recovered at her instance.
Yes,
My
but
lord,
she is not the assailant. But another thing, if your lordship want to see,
How long is she in custody?
my lord, since
my lord,
27th October 2023, my lord.
3 months we have completed 10 witnesses, only 9 more witnesses to be done. Next
But my lord,
schedule,
I'm
4
not.
witnesses are fixed on 7th of February.
My lord, I'm not the main accused, my lord, on any condition. Throughout, she has been from the date of arrest. Yes, there is distinction, my lord. When the
Paramour is in jail.
he is in jail, my lord, I am.
We have completed trial in a very fast manner, my lord, within 1
Why
year.
can't you do that in every matter, Mr. Sinha?
My lord, your lordship
And
knows this.
and my lord's one of
Section 34. Oh,
my lord, one of the witnesses.
Next schedule.
My lord, the next scheduled 4 witnesses are my lord,
February
7th of February, CSW 11 to 14 are to be examined, and 5 more will be left. My lord, another schedule we will complete.
My lord, she has not assaulted, my lord.
3 months we have
What is the
completed.
deposition?
Yes, my lord. Yes, my lord.
Sorry.
My lord,
Deposition copy, some, my lord.
My lord, we will have to go through the depositions because I do not have.
Go through the deposition.
আমি তো বলতে
Let him hand it over, my lord.
Go through the
If
deposition.
there are clinching
Hey.
evidences which are
The petitioner is the wife of the victim. Stop. The allegation, the prosecution case is that the petitioner had an extramarital affair with a gentleman, with a person who is in judicial custody. Stop. That person and the petitioner conspired
My
to
lord, they were found in a compromising position when the
conspired
conspiracy has not been mentioned, my lord. On spot,
victim.
he assaulted.
Stop. Paragraph. We are told that how many have been examined? 10 prosecution witnesses have already been examined. Stop. Learned state advocate tells us that the trial is likely to conclude within a short period of time. February 7
is fixed for trial evidence of 4 witnesses.
1 day.
No, 3 days.
February 7, 8,
No, 5, 6, 7.
February 5-7, 2025 have been fixed as the next schedule for examination of 4 more witnesses. Paragraph, copies of depositions of the witnesses already examined have been made over by learned advocate for the petitioner to learned state advocate. Stop. Let learned state advocate scan such evidence and tell us on the.
Not yet handed over.
Will.
Record হচ্ছে আমি দিয়ে দেবো
And tell us on the next date, to what extent, if at all, those witnesses implicate this petitioner. When will you come back?
762.
22nd.
And my lord, let them also produce that bedded tickets, my lord, because dying declaration supports me, my lord. I beg to rely upon.
So it should be there in the CD then.
It must have been, but I have not found it.
Look.
I will look into it.
how you have got this?
My lord, copies supplied, my lord.
Then certainly it would be there.
Yes, my lord. Copies supplied. I am attending trial, my lords.
51.
I'm praying for the petitioner.
Yes.
My lord, I'm praying for bail on the ground of parity, my lord.
Lucky.
Yes.
Lucky to have obtained a bail.
He is similarly circumstanced with another
Otherwise, on
co-accused.
merits, the case was very bad, but since co-accused has already been granted bail by your lordship, sir, only on the ground of Article 21, and he's also in custody from the same period. He was arrested on the
1
same
month
day.
more.
1 month more, because
Issue. The petitioner claims parity, citing an order dated December 23, 2024, passed by a coordinate bench in CRM DB 3067 of 2024, comma, whereby a co-accused person, comma, Shukhendu Das, comma, was enlarged on bail. Stop. The petitioner says that he stands on the same footing as Shukhendu. Paragraph, learned state advocate, while opposing the bail prayer, comma, in his usual fairness, comma, does not dispute that this petitioner is similarly circumstanced as Shukhendu Das. Stop. Paragraph, hence, on the ground of parity, we allow the petitioner's prayer for bail.
But, may I just point out, my lord, parity with regard to the detention, not on merits.
So we can does not dispute that this petition is
Because on
similarly
merits would have to make
circumstanced as Shukhendu Das, insofar as the period of detention is concerned.
Charges are under section 302, 201 and 34. My lord,
The same
here-
condition গুলো দেবে অর্ডারটা যেগুলো আছে।
Here, my lord, my first claim of argument, my lord, that the petitioner, my lord, is also entitled to bail on the ground of parity. Although, my lord, on previous two occasions, lord, prayer for bail was rejected by the coordinate bench only on the ground that certain incriminating, my lord, articles were seized from the custody of the petitioner. That apart, my lord, there's no other ground. My lord, the petitioner is in custody for more than 2 years. My lord, there is little progress in the trial. My lord, moreover, if your lordship sees, my lord, the allegation has been made against unknown, my lord, the assailant. My lord, what has happened, my lord, on 20th November 2022, a missing diary was lost with the Dinajpur police station. That the victim, my lord, the complainant's daughter.
Very well, Mr. Kali, once again. What is the stage?
My lord, charge frame March 24. Thereafter, only one witness has been
Out of?
Out of 24.
And 2 years, more than 2 years in custody?
Yes.
My lord, that's true.
File a status report.
My lord, I have the status report with me.
Not answering the questions we will ask.
My lord,
How many more witnesses will you examine?
my lord, that I have asked the concerned officer in charge, but he did not provide those information. I have requested the SP. Thereafter, this report.
On any condition, my lord.
Then, sir, then we will have to proceed on the basis that we will examine all 24 witnesses, which will take about 5 years.
Because the officer in charge is not cooperating. I have asked him, I have given him WhatsApp message. In spite of that, no information are coming. my
Two
lord.
other already enlarged on bail, my lord. Two other.
How many accused?
3 accused
But,
altogether.
my lord, not on same footing.
Well, that's
because-
that at the
because
outset I have submitted.
belongings- Because the body was recovered, decomposed body was recovered. Thereafter, body was identified by his father, by her father. My lord, and the belongings of the deceased victim, while he was taken from his home by the lover of the victim, my lord, the belongings were recovered from this
Well,
petition.
the allegation is
Only
still
on this ground, the coordinate bench
my lord, that cannot be the sole ground because my lord, there are 3 accused standing on the same footing. But since only my lord, because of the fact
Concluded. Can you give?
No,
2 years I am in custody, no progress.
No asking.
Sir, the last rejection
But
was
kindly, my lord, any condition, my lord.
That's
November 23.
my lord, that
My lord, kindly on any condition, my lord. I am languishing in jail for 2 years.
The petitioner renews his prayer for bail, which was twice rejected on merits, comma, firstly on June 5, 2023, and then on November 16, 2023. Stop. He says that he is in custody for more than 2 years. Stop. Only one out of 24 charge sheet named witnesses has been examined. Stop. There is no possibility of an early conclusion of the trial. Stop. He renews his prayer for bail on the touchstone of Article 21 of the Constitution of India. Paragraph, the state has filed a report. Stop. Let the same be kept with the records. Stop. The report is not very helpful. Stop. It does not say how many more witnesses the prosecution intends to examine. Paragraph, we see that charge, when was charge sheet filed?
my lord, charge sheet filed, my lord, 17th March 2023.
We see that charge sheet was filed on March 17, 2023. Stop. Charge was framed.
My lord, March 2024.
Only one, only one witness.
On
did
March
that.
2, 2024, i.e. after 1 year from the date of
Only one witness,
filing
that
of
was
charge sheet.
complete.
Stop. Since framing of charge, only one witness in full, examined in full.
My lord, one complete.
That also not, my lord, it appears part.
My lord, one completed, second is going on.
One witness has been examined in full. Stop. Therefore, we find delay at every stage of the trial. Stop. There is absolutely no possibility of an early conclusion of the trial. Stop. The petitioner cannot be kept in incarceration for an indefinitely long period of time, as that would infringe his fundamental right to personal liberty and speedy trial, enshrined in Article 21 of the Constitution of India. Paragraph, without touching the merits of the case and solely on the ground of inordinate delay in progress of the trial, coupled with zero possibility of early conclusion of the trial, we are constrained to enlarge the petitioner on bail.
Grateful to your lord. Shall not enter Raiganj PS jurisdiction. And shall intimate the local address to the IO and Learned Trial Court. And shall meet the IC of jurisdictional police station where we currently reside. Okay. Grateful to you.
Deeply applied.
Once in every week.
But
164 is time.
he's unwell. Unwell. No. No, cancellation. But I'm for the petitioner item number 53.
I was seeking an accommodation.
Humble prayer, my lord.
Accommodation?
I was seeking an accommodation.
Huh?
I was seeking an accommodation for this state.
But I just have a humble prayer. The petitioner is extremely unwell, my lord. He's had a brain surgery. He's never been produced before the trial court till date. My lord, if a report can be called with regard to his medical condition.
How long is he or she?
2.5 years, my lord. He. 2.5
Not
years,
produced.
He has been produced. He has not been produced on a regular basis, but he has been
Actually.
No, my lord. My lord, no production despite
there has been
the orders of the trial
actually.
court. If a report can be produced, I would be grateful.
The petitioner says that he
My lord, he.
is in custody for about 2.5 years. Stop. He has never been produced before the Learned Trial Court. Stop. He is extremely unwell. Stop. He has undergone a brain surgery.
Got you.
Paragraph, let the state file a status report as regards the trial. Stop. The report shall also indicate the health condition of the petitioner. How soon can you file?
District Murshidabad. So one week time.
22nd.
Got you. My lord, grateful.
Yeah.
My lord, I'm for the applicant, my lord. Our service is not completed yet, your lordship.
Yes.
I have served yesterday, my lord, but service is not completed yet.
Service not complete.
No, my lord.
Not complete. Learned advocate for the petitioner says that service is not complete. So let service be effected and affidavit of service be filed in court on the next date.
My lord, apart from the cancellation, there is another issue. Kindly dispose of that issue first. My lord, The cancellation is on the ground that after your lordship's prayer for bail was rejected.
That was suppressed before the trial.
Yes, yes.
No. That is
No,
that is
that's a different issue.
I have gone through. Initially, he claimed that he signed the Vokalatnama. Subsequently, he refused that I did not sign Vokalatnama. So, as there is that cannot be said that his bail prayer was rejected. Yes, okay.
Weak hours a day. Weak hours a day.
As if not pressed.
Lordship.
As if not pressed. So, if he gets bail in the district judiciary, it should.
No, I am not on that.
I'm telling you, I have considered yesterday.
Not that. I am not on that. I am not on that. Your lordship had directed.
Now, I accept all your suggestions, but you say that in the Hajat, the production before the court of law for the first time, the court has to give some.
No, not the court. Yes.
No, that cannot.
My lord, otherwise, what will happen is, my lord, then that the mischief your lordship wants to prevent, that is the main area where the mischief
Another
is.
thing is that in the police station, no Vokalatnama will be signed. Why?
Yes, definitely. Yes, definitely. Why not?
No evidence.
Why not? Why not? He is being
We
produced.
have to consider both of us.
Yes.
Consider.
No, no, my lord.
Time to discuss.
No, I am saying I am not the authority. My lord, they have given an opinion that they are to consider all the applications. If they are to consider the applications, your lordship is the last authority. Some workable solution so that meanness can be stopped.
Yes, we have initiated.
Your lordship has initiated. Definitely, it is my suggestion only. End of the day, it is your lordship who will decide.
No, but
And your lordship is deciding in favor of us.
Yes.
Us.
For the sanctity of
It's
legal.
the black coats.
Yes.
the bail petition which we rejected, what is the number of that?
2856.
2856 of 2024.
Oh, so 1115, triple, that's the next matter.
That is the cancellation.
So this 1115 ta dush
In this matter, 1032 is concerned, my lord. My lord, this cancellation.
1032.
Yes.
Lordship, I am
Oh,
here for the
1032.
private respondent led by Mr.
My lord, 1032 means cancellation for bail. My lord, I am seeking for your lordship's time, my lord. Probably we'll see the status of the trial. If the status of trial progresses, we may not press this application.
শোনো আগের ম্যাটারটাও কি বলছিল আমি বুঝতে পেরেছি ওটা মার্কস 3 PM করে দিও বিশেষভাবে তো আজকেও তো করা আছে না ওটা মার্কস 3 PM অর্ডারে দিয়ে দিও আর ব্র্যাকেটে যেরকম আছে আজকে ওটাও সেরকম থাকবে
So far this matter is concerned, we file an application for bail. Now I will take instructions so far as the status of the trial, my lord. If we find the trial has been substantially progressed, my lord, then we may not press this application. Kindly fix it upon 27th or anytime thereafter we can take instruction. If we find that trial is proceeding, that there is no reason for pressing the cancellation application, we may not proceed.
Learned advocate for NIA
Take instruction, my lord.
seeks a little time to obtain better instructions. Stop. Paragraph, let this matter be listed again on 28, January 28, comma, retaining its position.
My lord. Lord, we are appearing for the CPI.
I'm appearing for the opposite party, my lord, led by Mr.
For CPI, this cancellation of bail, my lord.
Cancellation of bail.
Yes, my lord. No. My lord, defective complaint filed the application, my lord, for cancellation of bail. And
Which what is defective complaint?
Lord, defective
For the defective complainant seeking not to demilot, I'm led by Mr. Mohit Mukherjee. He is on his legs in courtroom number 7.
Cholo. You are for?
Your lordship is aware that they
For the accused.
I am for the accused. Well,
They are
there was-
asking for accommodation, Mr. Gankar.
the last occasion, this was the same prayer which was made on behalf of Mr. Mohit Mukherjee. Even on the last occasion.
You are on bail.
What had happened, I was on bail. They had challenged it before this honorable court. As per the direction of this honorable court, I was restricted to stay within the district within which my house was situated. I am out of my house for about 16 months. No, not Nanu. Not that case.
Nondigram.
Now for about 16 months, 16 months, I am out of my home. I had prayed for relaxation before your lordship. The CBI and the de facto complainant had vehemently said that since the main matter is pending before your lordship, they want that matter to be disposed of so that my prayer anyway will become redundant at that stage. So that's why your lordship had fixed it for hearing. Since then, Mr. Mukherjee has been asking for time.
No. On the last occasion, the matter.
One day accommodation. He is on his legs in courtroom number 17.
On the understanding, madam, that on the next Tuesday, if he is busy or absent, you are going to do the matter. Yes. Grab this opportunity. Argue. When were you enrolled?
Big matter. You have got this big matter.
Mirror instead of
Every day's adjournment amounts to a week's adjournment primarily. But anyway, let your lordship
This
will
is the last
record that this is the last occasion and no further.
Again, accommodation is prayed for on behalf of the applicant.
22nd, my lord.
Stop.
The 21st
Your application is
may
pending.
not be.
Relaxation?
Cancellation, my relaxation is pending.
Pending. Stop. As a last opportunity to the applicant, comma, let this matter stand adjourned and be listed again on Shamner Mongolbar, comma, retaining its position.
Lord, one thing may I pray, Lord.
Huh?
Lord, instead of 21st, Lord, 22nd, Lord.
That is not cancellation day, Mr. Paiti. Oh, 21st to trial court. But you will come back by 3 o'clock.
They are the petitioner, we are the applicant. And the opposite party there.
No, in this application,
My lord, it's an application for cancellation. They are the petitioner. In that cancellation application, we have filed an
তাহলে ওটা
we have filed an
petitioner
application, so we are
না করে
applicants.
petitioner করো।
They
You won't be back by 3 o'clock.
My lord, I will try, my lord, because charge for remember charge, my lord. I will try to, my lord.
Let them complete, my lord, at least. Thereafter, your lordship can always fix it for hearing this
Yes.
CBI.
Tuesday, next.
State is the petitioner, madam. State has paid for cancellation.
You served.
Item delivered.
You served on the BA accused.
Huh? Affidavit? Huh? Affidavit is linked. হাজার 34
Mr. Kesri, who appeared for the accused when bail was granted?
I'm sorry, my lord, 1,000.
Bail granted by this court or
Sorry, my lord, I think I've handed over the wrong affidavit.
wrong affidavit?
Oh, this is my lord, some other matter, my lord. Here, my lord, I'm for the petitioner, but it's a private application, my lord. On behalf of the de facto complaint.
For the accused, my lord. For the
Service
accused.
complete.
Yes, service, my lord, earlier complete, pleadings also complete. They had filed their opposition. The reply is before your lordship now. The opposition has, the reply has also been served. So the pleadings here is complete. But the application here.
What did you file
cancellation-
today? Who are you?
Well, for the accused, my lord. Well, the de facto has taken out the application, my lord. They are not
This
present.
is not present. Who's not present?
Sorry, sir.
You are the de facto. State?
State, my lord, this is an application where, my lord, we had paid for cancellation of a particular order granting bail. On surrender, the accused has been granted bail under the provisions of the Foreigners Act. Now, the contentions, Foreigners Act, granted bail on surrender. Now, if your lordship sees the tenor of the order, your lordship will find.
My lord, before my learned friends started, my lord, the learned advocate on record is sick, my lord. For a couple of days, my lord, if this can be postponed till next Tuesday.
Affidavit in reply filed on behalf of the petitioner. Be kept with the records. Paragraph on the prayer made by opposite party number 2.
My lord.
On the prayer made on behalf of Koro. The opposite party number 2, comma, let this matter stand adjourned and be listed again Shamner Mongolbar.
Much obliged.
Let it retain the.
Comma, retaining its position.
Hello. हम देख ले रहे हैं कौन किसका सर्विस एफिडेविट का कॉपी दे रहे हैं
Madam, I am for the accused opposite party.
Your Lordship, Mr. Oyen Bhattacharya is appearing for the petitioner, Your Lordship. I am praying for not today on his behalf, Your Lordship.
Madam, Lordship, kindly have a look into the earlier order also.
Why again adjournment? On the prayer made on behalf of the petitioner, comma, let this matter stand adjourned for the day and be listed again on Shamner Mongolbar. We have recorded it. Next time we'll dismiss it.
4 weeks, my lord.
No. Next Tuesday.
My lord, I am for the opposite party, my lord. I served the opposition, my lord, but due to some difficulty in AFHAM, my lord, I pray not today, my lord. But yeah, one copy is only single service.
The service is complete. Mr. Ghosh, take a copy.
I already served.
You've given. You're filing it in court.
My lord, the second judge copy, my lord, was some difficult, was some dispute, my lord.
On the prayer made on behalf of the private opposite party, comma, let this matter stand adjourned and be listed again on Shamner Tuesday. Bail granted by this court or?
No, my lord. Below, my lord. Same, দুটো same.
1037, same order.
Yes, ma'am. I have the statement.
Where is the accused?
I've served the copy, my lord. Affidavit service perhaps I filed last day. The affidavit service has been filed earlier. Let it be informed through the state agency if it doesn't appear.
They have never appeared, na? On the last 3 occasions, the opposite party numbers 2 and 3 were not represented. Stop. Paragraph let the state, through its machinery, effect service of notice of this application for cancellation of bail on the opposite party numbers 2 and 3
2 and 3.
and file service report in court on the next day.
Mine.
Paragraph, এটা থাকে কোথায়? থাকলে তো হাওড়া. Then next Tuesday.
Next Tuesday.
Next
Mine.
Tuesday.
Deeply obliged.
Item to লিখে দিত Next Tuesday.
My lord, I was appearing for the accused respondent, my lord. The plight is that I could not contact with the client, my lord. I want to be released from this matter.
You want to be released from the matter?
Last occasion they wanted
the
time to
affidavit-
file the affidavit in opposition.
My lord.
Or probably not getting material instruction.
Their material
Not in instruction. I have several times I have contacted with him, but
Material, immaterial.
nothing.
no, sir. Couldn't know.
That event, my lord, whether your lordship will proceed, I can.
No.
Notice has to be. Let the state. You are the state.
Yes.
We had
State is the
served.
petition.
We have served.
Yes, they had appeared.
We'll grant 1 week's time if they engage somebody else.
My lord.
Point is, whom did you serve? You have served on the
I've
parties.
served on the party.
Parties.
Directly. Served on the party.
Learned advocate for the. How many opposite parties are there? For the opposite party number? Oh, one opposite party.
One.
Learned advocate for the opposite party says that he would like to retire from the matter. Stop. He is granted leave to, but then state you serve another notice that their advocate has retired.
In the meantime,
You will know?
fresh serve.
We grant him. We grant him leave to retire from the matter. Paragraph, the state shall serve a notice on the opposite party to the effect that the learned advocate whom the opposite party had engaged has retired from the matter. Stop. The opposite party is at liberty to appear in person or engage new advocate. Stop. Otherwise, the application for cancellation of bail may have to be proceeded with ex parte. Paragraph lists the matter 2 weeks hence. Date ta diye dao.
So 1040, I'm for the state, lords.
Appealing for the accused. Pursuant to your lordship direction, I have prepared the affidavit in opposition. And it has been, yes, madam.
Where's the de facto?
That means,
With the de facto.
cancellation.
Cancellation is the application of high state.
Learned advocate.
Huh?
May I file this affidavit in reply? Opposition, sorry.
আমাদের কপি
আমাদের একটাই কপি আছে। আপনার নামটা লিখে
The
দিন।
petitioner is not represented. Stop. না, state নাই তো। নাম রয়েছে তো।
On the last occasion, he appeared. And there was a.
Is not represented today. Stop. Affidavit in opposition filed on behalf of. You are for 2, 3, 4, 5, 6. On behalf of respondent numbers 2 to 6. be kept with the records. You are for the state.
No, sir, I'm for the state. The conic I directives have the copy.
Yes, I said.
Give him,
I
give
had
him.
only one.
Paragraph.
Xerox.
The petitioner will be at liberty to file affidavit in reply within 2 weeks from date. Paragraph lists the matter 2 weeks from date with advance copies to learned advocates for the opposite parties numbers 226 and state. Paragraph lists the matter 2 weeks hence.
Already that direction was there on Lordship's idea.
We are extending the period.
I'll get owner number, so that we can serve. I'll get.
Lordship, I am for the state, Lordship.
My lord, I am for the petitioner, Lordship, de facto.
Have you served?
Lordship, I have served affidavit of service.
How many copies you are giving? Affidavit of service?
I have served.
What do I have served?
Lordship,
কজন জজ আছেন এখানে?
I beg your pardon, Lordship, sorry.
কোথায় ট্র্যাক রিপোর্ট কিচ্ছু নেই।
There's a track report, sir.
Where is the evidence of service?
Lordship, pray for not today. I'm extremely sorry.
They will not help you.
Consider it.
Get the track report. There's no track report here. ফেরত দিয়ে দাও, ফেরত দিয়ে দাও। Just simply not today.
Lordship,
From India Post, you have to download.
Lordship, track report I have annexed and come back
With the track report, yes.
Lordship, come back with the track report.
2 copies.
Lordship.
For the private opposite party accused, the affidavit opposition's ready.
My lord, I am for the petitioner. My lord, no opposition has been served করেছো?
Affidavit in
My lord, the
opposition.
affidavit in reply needs some time to file.
How much?
My lord, 2 weeks, my lord.
Affidavit in opposition filed on behalf of the opposite party oblique accused. Be kept with the records. Stop.
একটা opposition এর copy দিন।
The petitioner will be at liberty to file his এটা কি 1042
1042.
his affidavit in reply within 2 weeks from date. Paragraph lists the matter after 2 weeks.
Kindly direct my land.
Oh, I'll serve him.
Huh?
I have not been served.
I'll serve.
Give.
Today or tomorrow I'll serve.
No, today. Today.
আমাকেও একটা কপি গুলো হারিয়ে ফেলেছি। Grateful ছিল। এই কপি দিও।
এই মামলা
I'm for the statement.
I am for the opposite parties, number 225. I am filing my affidavit in opposition.
affidavit in opposition.
Yes, sir.
এই
একটা কপি দিন।
যা আগেরটা ছিল affidavit in opposition filed on behalf of the opposite party oblique accused be kept with the records. Paragraph the petitioner will be যা ছিল liberty to file reply within 2 weeks.
Direct them to my lord to serve my lord.
একটা তুই হ্যাঁ দিয়ে দেবো
No copy has been served my lord from the
give
Yes, Mr. Adasha.
1044.
नहीं चलो Passover.
1045.
I am for the petitioner, my lord.
My lord.
I am for the petitioner. Kindly
Affidavit in opposition.
today just received the affidavit in opposition, my lord. I
2 weeks. 2 weeks.
2 weeks, my lord. Reply to
You're the accused.
I'm the accused.
I'm appearing for the state.
Hey, same order. Affidavit in opposition filed on behalf of opposite party accused. Liberty to file reply 2 weeks. List after 2 weeks.
slip them এটা
My lord. My lord, I am appearing for the opposite party number 2.
My lord, I am
My lord, affidavit in opposition, my
It's for
lord.
the petitioner.
Mr. Purokas.
Direction for affidavits was given.
Kindly give 1 week time.
My lord, there was a
Chilo.
direction for
Direction for-
exchange of affidavits. My lord, so far the opposition is concerned, my lord, we have raised the opposition. It has gone for affirmation. My lord, in
Yeah,
course
that's
of
why-
tomorrow we shall.
That's why
He wants 1 week.
Yes.
You are for OP number 2. And OP1 is the state.
I am for 3 to 5.
Uh,
You all are led by Mr. Mo.
on the prayer made on behalf of the opposite party number 2, time to file affidavit in opposition is extended by time to file affidavit by a week from date. Bracket tarikh 1 week manager. Paragraph no honey. Reply thereto, if any, be filed by the petitioner within 2 weeks thereafter.
My lord.
Abar date ta diye debe. Huh? Paragraph lists the matter after 3 weeks. Date ta diye
I'm
debe.
grateful, my lord.
কাগজ নেই কাগজ নেই ছোট কাগজ নেই দিয়ে দাও
My lord, I am for the applicant. I am not pressing this application, my lord. I am for the applicant, my lord. I am not pressing this application.
Very well. The petitioner says, no, the learned advocate for the petitioner says that she is instructed not to press this application for cancellation of bail. Paragraph CRM such and such.
I am for the private assignment.
Nahi.
Earlier
Petitioner not there.
occasion also, earlier occasion also same, my lord, not appear.
Last day also did not appear. Sure.
Yes.
Please go.
Not interested, my
এই দেখি একটা ফাইলটা দাও তো এটা নাহলে আজকে সেকেন্ড কল বুঝিয়ে দেবো আপনার অর্ডার কি আছে দেখি কি রয়েছে
ছবিটা
কাজে কথা বলছি
ছবিটা
কাজে কথা বলছি এই পাস ওভার করো Passover. Petitioner appeared. Why are you saying did not appear? We have recorded.
No, lastly, my lord, not appear. Lastly not appear. That's lastly not appear. The civil dispute in nature, totally civil. 490 day case has been filed.
Sir, in the second call, if they don't come, we'll dismiss it.
Or I am appearing on behalf of the petitioner.
I am appearing for the opposite party. Lord, may I just indicate I had sought time to file an affidavit, but I have not been able to file the affidavit.
How much?
Lord, I require 2 weeks time. But in the meantime,
1 month back, but 4 months I was on the hospital bed. This is what, and he is a dreaded criminal of that
can I
particular
just
area.
say something?
Lord, I have just
in
put-
custody in connection with another matter.
That is
so. My lord, can I just make a small prayer? I'm sorry, my lord. I'm extremely sorry, my lord. Mr. Roy,
Is there an MB? Is there an MB?
My lord?
Yes.
Is there an MB?
But it doesn't suit him, my lord. I was just telling him he should have a Gandhi. MP Gandhi.
Hey Ram is the only expression that I can give.
Mr. Edulji, Mr. Banerjee was in difficulty, couldn't draft. 2 weeks, 2 weeks. You want 1 week for reply, no?
1 day. For
But
one
may I
day, I'll
just say,
prepare the reply.
Keeps it after.
But this is a very serious matter. Otherwise, my lord, I wouldn't have this
Just
thing.
make a small, my lord, before your lordship passes.
Granting time.
No, item number 446.
No, those are two completely different
Lord,
matters.
may I
One
just-
is for cancellation, one is
Can
for
I
bail.
just say
How can they
something
be tagged
that
together?
I am saying? Can I? It's my petition. 446 is of the next police station where I have been picked up. I am in custody while I was released in bail in this. But there's no. This will be a futile exercise if the other matter is also not heard out. I'm not saying that don't hear him. I'm saying hear my other application also.
Mr. Banerjee, no upgradation. We'll hear it as and when it is taken up.
Then both matters.
Serially, no question of tagging, clubbing. You file your affidavit here first, then we'll see. On the prayer made on behalf of the opposite party of the
28th.
accused, huh?
I'll be able to file it by 28th.
28th.
I'm in custody. So
Comma, time
can't
to
be-
file
Well,
affidavit in opposition is extended till August 28,
No,
January 20, January 20, comma 2025. So reply thereto, comma, if any, be filed within a week thereafter. Paragraph, sub date diye debe kintu. Paragraph lists the matter once again 3 weeks hence, our date ta diye dao, comma, retaining its position.
Extremely grateful.
For the opposite party.
And I'm for the petitioner in this matter.
I am for the state.
I'm for the petitioner in this matter.
I
I'm
am
virtually
for
connected.
the state. I am late.
Why virtually?
I'm not feeling well.
Then you shouldn't be doing the matter.
I'm not feeling well. I'm suffering fever.
Oh, then you take rest. Calpol 1000 milligram, thrice a day.
Be given to serve a copy upon me. I
Service not complete, Mr.
No,
Ganguly.
sir, I have served, but it has returned. It is insufficient address. I will serve by tomorrow.
Now learned advocate is appearing. You can serve her. Ask your junior or whatever. We are learned advocate for the opposite party oblique accused says that service is not complete. Stop. Let service be effected and affidavit of service be filed in court on the next date. Paragraph lists the matter once again on Shamner Mongolbar kore dao. Next Tuesday.
I'm getting it.
I am for the opposite party number 2.
I am for the petitioner, my lord.
I'm for the state.
Last occasion, my lord, on 3rd December 2024, my lord.
Affidavit of opposition has been ready, my lord.
Copy is served.
What is this?
Affidavit of opposition. Just now
Give copy. File your reply if you want to. Affidavit in opposition filed on behalf of the opposite party. One opposite party.
Yes, ma'am. Yes.
Oblique
No,
accused.
state.
Be kept with the records. Stop. The petitioner will be at liberty to file his affidavit in reply within
1 week, my lord. Next
within
week,
a
my
week from date. Paragraph lists the matter.
Next week.
Next Tuesday.
Next week I have some difficulties.
2 weeks hence, date ta diye dao. 2 weeks hence, date ta diye dao.
I'm grateful. I am, my lord, served. I have received. নামটা লিখে নেবেন কাগজ তো নেই কাগজ নেই এখানে লিখবো কোথায়
1052
I am for the
কাগজ দিন
private opposite party, my lord.
1052 petitioner not there. Chalo.
Action petitioner? No. Hard time petitioner is not there.
Have we recorded that? 1052 file now.
Not present now. Main petition is defective because the impugned order is not part of this petition.
But you are sure the petition did not appear? Second call, we'll dismiss it.
Lordship.
Passover, chalo.
Passover second call করবেন because I am carrying the original case diary since August 2024.
Acha. We'll do something today.
May it please your lordship.
I am for the
I am for the petitioner. Where on the last occasion, your lordship, you are pleased to direct the opposite party to file affidavit in opposition on
last day, matter came up on 26th
Thou-
November. It was
No,
none appears for the petitioner. It was dismissed. On the same day, it was later on. It was restored.
Yes, then affidavit direction was given.
Subsequently
Have
on
you filed affidavit?
December 3rd December 20.
Give me some time. I will.
What?
Subsequently on 3rd December, the opposite party was appeared before your lordship, and your lordship was pleased to direct before to the opposite party number 2.
Accused was not there, not recorded in the order, sir. 2 weeks on the prayer made by on behalf of the opposite party oblique accused, comma, time to file affidavit in opposition is extended by 2 weeks from date. Bracket diye debe date ta. Stop. Reply thereto, comma, if any be filed within
2 weeks.
Within 2 weeks thereafter, our date ta diye dao. Paragraph lists the matter 4 weeks hence. Our date ta diye dao.
Grateful.
Copy be served to the state also.
They should. You are a party, aren't you?
I have no
Great.
আচ্ছা
My lord, I am for the petitioner, my lord.
Last question.
Service complete?
Yes, my lord.
Last question, Your Lordship, please to direct me to serve upon the opposite party, my lord.
So I am for
Service
the
has been-
opposite party. I am praying for file the opposition, lordship.
Service report filed by the state be kept with the records. Stop. The opposite party oblique accused is represented today. Paragraph এটা হচ্ছে 1054. The opposite parties will be at liberty to file affidavit in opposition to this application for cancellation of bail, comma, within 2 weeks from date. Stop. Reply thereto, comma, if any, be filed
1 week.
within a week thereafter. Stop. Paragraph list এসব করে date দিয়ে দিও হ্যাঁ অপূর্ব list this matter 3 weeks hence date দিয়ে দাও হ্যাঁ
Grateful to lordship.
এইটা নিয়ে নাও সার্ভিস রিপোর্টটা রেখে দাও
My lord.
এই 5
My lord, I have tried to serve upon the other side. It has returned. I want to serve again.
state 1055 who is for the state Mr. Nondi you try to serve or shall we direct the state but we don't know who is appearing
My lord, if somebody be appointed, we to serve upon the state.
learned advocate for the petitioner says that attempted service on the opposite party oblique accused has been unsuccessful. Paragraph, let the state effect service of notice of this application for cancellation of bail on the opposite party oblique accused and file service report on the next date. Paragraph, list this matter 2 weeks hence. You find out and serve a copy of this order on the state. Paragraph, since the state is not represented today, comma, learned advocate on record for the petitioner shall communicate today's order to learned state advocate for compliance.
Not 5-6 and 5-7 for us. 2 orders in relation to the same
I have
case. my lord.
instructions to appear for the opposite party number
My lord,
2.
my affidavit
My
was
lord, the
served.
accused. But my lord, I have not received the copy of the application. But
Kindly
I do
see
not.
the tracking report.
But I do not dispute that. But the fact is, my
ঠিক আছে,
clients have
give
not
him
received.
copy, let him file opposition. You want hearing. Give him a copy. State is not appearing in this matter.
Yes.
Affidavit of service filed in court today, we kept with the records. Paragraph, the state and opposite party oblique accused are represented through learned advocates. Paragraph, the opposite parties will be at liberty to file affidavit in opposition to this application for cancellation of bail within a fortnight from date.
Lordship.
Stop. Reply thereto, comma, if any,
1
be
week,
filed
1
within a week thereafter. Paragraph, list the matter 3 weeks hence. সব
Right.
date গুলো দিয়ে দিও। Same order in both the matters.
Yes. 50 seconds.
1056, 1057. Same order.
Great.
I am for the petitioner.
I'm for the state.
My affidavit of service.
Accused.
But I am appearing. My junior was appearing. I gave him a chance to.
You are for the petitioner.
Yes.
But we were sitting.
Supposed to be.
But we thought we were sitting
we are going to
behind.
seek time,
because-
so we thought that the
No, no,
juniors will do
This
it.
is what happens when you become senior advocates.
But if we don't push the juniors, my lord, both of us took a conscious decision to.
Yes, affidavits exchange.
No, my lord.
No.
I would make.
But this is the service.
Affidavit of service, same order করে দাও 2 week, 1 week.
2 week one. I was
তাহলে what
wanting
do you-
time to. Oh, my 2 week one.
Date গুলো দিয়ে same করে দাও। Affidavit of service টা নিয়ে নাও।
এই এরকম করলে হবে না।
2 weeks, 1 week, 3 weeks hence.
এটা কি সার্ভিস চলে এসছে নাকি?
Passover. Your application.
Yes, my lord,
Service complete.
my lord, service complete, but it has, my lord, returned back.
Let the state serve.
As your lordship, please. State,
you-
because, my lord, we are for the NCB. That is the whole difficulty.
Oh, you are for the NCB.
Yes.
There is only one. Acha. Then you have to try again. Whom do we direct to serve?
Your lordship can ask Eco Park Police Station, his residence, so the Eco Park Police Station can serve and give a report to your lordships. Because we are the NCB, my lord, we have no knowledge so far as the, my lord, the outskirts of Calcutta is concerned.
Very well. তারে করে দিয়ে আর কি করবে? সার্ভিস করতে বলি। Hey, learned senior counsel representing Narcotics Control Bureau. Party নয়, আমি পুলিশকে আমরা পুলিশকে বলি। Says that attempted service of this application for cancellation of bail on the opposite party oblique accused has been unsuccessful. So paragraph.
Not unsuccessful, it was delivered, but it was returned back. Kindly see, my lord, the remark. Item delivered to sender. Now it has been returned back.
Sender means you.
Me, yes.
The item is not delivered.
Unsuccessfully.
Unsuccessful. So paragraph, let the, which police station?
Eco Park.
Let the inspector in charge. Let the IC, comma, Eco Park Police Station, comma, effect service of notice of this application for cancellation of bail on the opposite party and file a service report through an officer in court, not in court, and file a service.
Kindly engage someone from State Council or the PP or additional PP who can file a report before your lordship, whether it has been served or not. Then, my lord, the communication will be less. Otherwise, my lord,
and file a service report through the office of the learned public prosecutor.
Union of India মামলা
না
Union of India
হ্যাঁ।
petitioner
হ্যাঁ।
NCB is it you তাহলে স্টেট কি
না,
করে?
ঠিক আছে
They have been unable to serve.
পরে বুঝিয়ে দেবো।
You have to assist the court by serving.
They are accused person. NCB is the prosecution.
We are requesting the police of the IC of the police station to serve and file a
Order is communicated through the register to the IC.
yes, and file a service report through the registrar itself.
As your lordship,
Yes.
I have no difficulty.
He will and file a service report through the learned registrar general of this court. Paragraph, list this matter 2 weeks hence. Date ta diye dao. Paragraph, learned registrar general of this court is requested to immediately communicate this order to the IC, comma,
Eco Park Police Station.
Eco Park Police Station. Stop. Learned advocate on record for NCB shall make available to the IC of Eco Park Police Station a notice which is to be served by the police station on the opposite party. You have to do that. You supply them the notice, they will serve it.
Okay, we'll do that. We'll do that.
Eco Park for Kolkata. Hai.
Actually, it will be Bidhannagar Commissioner.
So what should we say?
Bidhannagar Commissioner.
IC Bidhannagar Commissioner?
No, IC Eco Park, but it will come under Bidhannagar Commissioner.
Oh, IC Eco Park under Bidhannagar Commissionerate করে দাও।
Deeply obliged.
কি হবে ম্যাক্সিমাম খিচুড়ি হয়ে যাবে।
Lord, I am for the petitioner. Lord, I am for the petitioner. This is the first time, my lord, appearing.
Serve.
My lord.
The learned advocate for the petitioner says that service of this application for cancellation of bail is not complete. Stop. Paragraph. Let service be effected and affidavit of service be filed in court on the next date. 2 weeks, 1 week.
1 week, my lord.
Where the next week? Next Tuesday.
My lord, grateful.
Passover চলো হবে না ডেকে দিচ্ছি হবে না চলো Passover 1063
Lordship, though affidavit of service has not been affected, Lordship, my prayer is limited to not to threat, not to intimidate. Upon the petition, upon the opposite parties who has granted bail. The copy has been served.
cancellation application. You're not asking for cancellation.
Not at this stage. I'm not asking for cancellation. Only not to Yes, I have served.
Where is the affidavit of
Lordship,
service?
affidavit of service is not ready.
How
The
do we
state
know
has
you
been
have
served.
served?
Only not to threat, not to intimidate.
Nothing.
I have never misused my liberty.
Nothing. No evidence of service of this application for cancellation of bail has been produced before us. Paragraph, let this matter stand adjourned for a week.
I'm grateful, Lordship.
Madam, may kindly record his submission then. He is
What?
not praying for cancellation.
Not at this stage, he said.
What is the stage?
It
Because
won't-
I am on bail since August 2024 and he is submitting in court, my lord, that he is
Very
not
well.
praying.
Come back
He has
after 1
filed an
week.
application.
Next, follow. Chalo.
My lord, I am for the petitioner. Narcotics matter is appearing for the first time. The
Wait,
service-
service. Let service be affected, huh? Affidavit of service. Next week or 2 weeks?
2 weeks.
2 weeks. One zero six six.
Mr. Moinur Rahman is appearing for de facto complaint.
Petitioner to keep. Petitioner is the de facto complainant.
De facto complaint. Owing to his illness, he has left the court.
Not today. Chalo.
Get
My lord, state has preferred this application, my lord. This is the first time, my lord, but he may serve.
Service. Affidavit of service. 2 weeks. Babu, বলছি না মনে আছে তো learned advocate for the petitioner says that service of this application for cancellation of bail is not complete. The paragraph, let service be effected and affidavit of service be filed in court on the next date. Paragraph lists the matter 2 weeks যেখানে 2 weeks, 1 week যেখানে 1 week, ডেটটা দিয়ে দিও।
I am appearing for the petitioner, lordship. It's appearing for the first time.
First time, service, 1 week or 2 weeks?
2 weeks.
2 weeks. 2 weeks.
My lord, appearing for the first time.
First time, same service order করো।
My lord, opposite party number 2 and 3. Service? No, service.
2 weeks or 1 week?
My lord, the opposite party has appeared, although I have not served, my lord.
You
So, my
have
lord,
to
he'll
serve
fix it after 2 weeks, my lord.
2 weeks.
I'll give a copy.
আমার কপি তো
No, sir. After number 2.
877.
I am for the petitioner. So this is also first time, though. My lord.
First time, serve, affidavit of service, 2 weeks. Passover, chalo. Passover.
This matter, state has filed this petition on behalf of the state GST. My lord, the accused was granted bail within 13 days.
Service.
Service, but my lord, I'm praying for a day's accommodation because my lord, there is some instruction regarding not pressing. So, but I don't have any written instruction.
Not today, not
So, my lord, I'm praying. Grateful, madam.
Passover. First time?
Service is affected.
Let us see the affidavit.
এটাও একটা
One copy. Mr. Ghosh, not from you.
Today is the first year.
Service, complete service. File affidavit of service, 2 weeks.
Yes, ma'am. 2 weeks.
Give your appearance.
Yes.
Passover. Passover, huh? Passover. First time here for the petitioner. Effect service, file affidavit of service. After 2 weeks, it will be listed.
This is also.
তাহলে সার্ভিস করেছি আমার 1 সেকেন্ড দাঁড়াও তো তুমি এবার this 345 matter our learned advocates here it will be adjourned on the ground of Mr. Mukherjee, I suppose.
I don't find Mr. Nondi also, blood. I don't find Mr. Nondi also.
Anyway, all of Mr. Mukherjee's matters have been adjourned today.
Yes.
So not this week.
So blood, not this week.
Not this week.
Only blood, can it be only not today?
Very well, not today for the time being.
Only has requested not this week.
Not this week. Chalo, ebar abar ডাকতে থাকো.
So blood, Monday 3:45.
That we don't know.
But your lordship has
Previously, let Mr. Mukherjee be back in court. We are told he's unwell. That is why. Let him come.
1080.
Same order, service here order karo. 2 weeks. Eight one, Passover.
It's my application.
Service complete.
If not-
Serve. 2 weeks.
Only one thing, my lord. The second time.
Lord, I am appearing for the victim in this matter. I have also filed the application for cancellation. My lord, that may be tagged with this application because both of us is praying the same thing.
Give the number.
My lord, the other thing is, my lord,
Of 2025.
my lord, there are two, my lord, state is the applicant, my lord, here. My lord, now this has been preferred, my lord, against three persons, my lord, three accused opposite parties. Now, my lord, they had a reason, they arose out of, my lord, two criminal miscases, but we have filed it in one application. In case, my lord, may kindly grant us the liberty, my lord, I shall file, my lord, another court fee with this, my lord, instead of, my lord, withdrawing and filing afresh.
Usual order টা করে সার্ভিসে তারপরে লেখো leave is granted to the petitioner
My lord.
to pay additional court fee
My lord.
if any is required.
Grateful, my lord.
Stop. তারপরে লেখো let give your number.
CRM DB number 190 of 2025.
পেয়েছো ওটা কি বললো CRM
190 2025.
be tagged along with this application.
What was
No, of 190 of 2025.
Yes, ma'am.
Being an application for cancellation of bail filed by the victim.
Victim.
Comma, be tagged along with this application. You serve in your application.
Yes, ma'am.
Tag করে দাও এটা এটা should.
তুমি কি এটাতে সবকটা করেছো?
ওই লিস্টিং হবে এটা তো 2 weeks পর সার্ভিস হয়।
My lord, and same, my lord, prayer, my lord, for 85, item number 85, my lord, arise of the same FIR.
85
My lord.
or
1085.
There also you have filed an application.
My lord, I will appear as victim in this matter. My lord, I have filed one application. I will.
তাহলে 1085 এ সার্ভিসের অর্ডারটা করে দাও আর কোর্ট ফি ডেফিসিট কোর্ট
No, my lord, no court fee.
তাহলে খালি সার্ভিসের অর্ডারটা করে দাও
Grateful, my
2
lord.
weeks.
Grateful, my lord.
আমি victim এর
1083 not yet, sir.
Service order করে দাও 2 weeks.
Not first time, need to
Service 2 weeks.
Eight six. My lord, I am for the petition. My lord, it has been served, but my lord, the affidavit of service, my lord, inadvertently I have only
Read.
one copy.
Oh, it has been served, received.
My lord, delivery confirmed to the addressee, but my lord, inadvertently it is one.
State you also effect service. From the file another copy.
Yes, my
Mr.
lord. My lord, in course of this day, my lord, I will be filed.
From the affidavit of service filed in court today, it appears that service has been effected on the opposite party oblique accused. Stop. However, nobody appears for the opposite party oblique accused. Paragraph, since this is an application for cancellation of bail, which may have serious consequences for the opposite party oblique accused, comma, let state effect fresh service on the opposite party oblique accused and file service report on the next date. Paragraph lists the matter 2 weeks hence.
Grateful. My lord, I am taking back the affidavit of
Yes, but file today.
My lord, file today. Grateful to you.
1087, this is appearing for the first time, my lord.
Serve service 2 weeks.
My lord, grateful.
Passover, cholo, cholo, cholo.
Once we and go to state cancellation. To start with the relaxation matter, they have prepared a relaxation and state has prepared a.
You have served.
They were appearing on the last occasion. We served them the copy.
Served. Then they are not here. Not today. What is that? Affidavit of service filed in court today be kept with the records. Paragraph, nobody appears for the opposite party. Stop. Paragraph, list the matter once again next week, next Tuesday. Yeah. কিভাবে টাইম ওয়েস্ট করছে
অন্যগুলো রাখুন
Passover.
First time.
First time. এই অপূর্ব একটু বুঝিয়ে দাও সার্ভিস অর্ডার মানেটা কি বুঝিয়ে দাও 2 weeks Passover.
I am for the petitioner state paper cancellation application is the first time, my lord.
2 weeks.
My lord, this state has preferred this application, my lord, for the first time, my lord, 2 weeks.
2 weeks.
For the petitioner first occasion, my lord.
2 weeks.
2 weeks, much. Great.
I'm for the petitioner lordship coming for the first time lordship.
It's 2 weeks.
One for the petitioner first time appearing. First time. State prefer this application, my lord, first time.
I'm for the petitioner appear for the first time.
2 weeks.
Lordship appearing for the first time.
Service 2 weeks. Passover.
But I'm for the petitioner, my lord. Service
Service
not yet affected.
2 weeks. Not service 2 weeks.
Great.
Lordship appearing for the first time.
Service 2 weeks.
I'm for the petition lordship first time.
Service Shondeep 2 weeks.
Item number 1108, my lord, I beg to appear for the petitioner with my broken voice, my lord, for the first time.
Service 2 weeks.
My lord, I'm appearing for the petitioner, my lord, first time appearing.
Same order 2 weeks. Passover. Passover. No, ये Passover. Passover second call. না কঠিন করে হবে না এই আমার যে usual orderটা হয়, in the first call nobody appeared for the petitioner. Stop. In the second call also nobody appears. Paragraph dismissed. Give appearance. করে দেবো। এই 1052 ছিল।
দেখাচ্ছে না তো ওখানে এটাও ছিল দেখায়নি কিন্তু
Dismissed. Same order. Dismissed. Only thing, Mr. Chatterjee, you know the practice is today they mention, then otherwise no.
Opposite to private.
ওটাও অ্যাড করে দিও, interim order if any stands vacated. Huh? Dismissed. Same. Same. না তুমি মিস করছো জহর। 1071 কি হয়েছে? 1071 নট টুডে হয়েছে শিওর। 1072 ঠিক আছে, আমি ভুল করেছি। 10 হ্যাঁ সেটা ঠিক আছে। 74 dismissed. হ্যাঁ same.
My lord, I am for the petition, my lord.
Yes.
My lord, for the first time, my lord.
Fresh matter? Service এর অর্ডার করে দাও। 2 weeks.
My lord.
1077.
Dismissed. Welcome.
1081.
Dismissed. Same. Nine one টা দেখো। Same. 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 Same.
1112.
My lord,
Same.
fresh matter.
Fresh service. 2 weeks. Same, dismissed. এবারে 1115 থেকে ডাকো। ও তাহলে তারপরেরটা এগুলো ক্যান্সেলেশন ক্রস কুপারে তাদের গ্রুপ ফাইল। এগুলো ক্যান্সেলেশন ইন পস্কো ব্যাংক।
Item number 1101 was cancellation preferred by the state lordship. Couldn't make it in the first call. It has been dismissed.
ওই 1101 এর অর্ডার করো না,
1081
First time lordship got direction.
সার্ভিসের অর্ডার করে দাও। 1101 এ অন্য কেউ অ্যাপিয়ার করেনি তো?
1081 I am for the petition.
1081
my lord.
your application?
Yes, ma'am.
ওটাও করো না 1081 স্যার ফ্রেশ ম্যাটার।
Yes, ma'am.
My lord, 1072, my lord, I am for the
সার্ভিসের অর্ডার করে দাও
1072.
We have called.
Yes.
Is this for second time?
1072 টাও তাই করো 1072 so not today.
Great.
Lordship,
1081.
Lordship 1052, not praise this application.
1052
Not praise.
not press ওই ডিসমিস ফর ডিফল্ট করো না নট প্রেস করে দাও 1052
52.
ডিফল্ট লিখছি দেখলি ফর ডিফল্ট।
হ্যাঁ, অঞ্জনা বিশাল যেটা। ঠিক আছে, নাম
I am for the opposite party in this case, my lord.
Passover service affected.
The service affected, it's a long going process, my lord. The proceeding is going since July 2023, your lordship. Only difficulty, I am outside my jurisdiction, my lord, since July 2023.
First call we will not dismiss, let us see. Passover, let us see.
Grateful, lordship.
Lordship, I am for the petitioner, Lordship. Here, Lordship, the petitioner was granted bail.
Service
X versus. Yes, X versus Vijay Pandey. Service done. So,
দাও ফাইল।
Lordship, affidavit.
1117.
Yes,
My lord, I am for the opposite party.
Accused.
this has been done, Lordship.
Yes, now everybody is here, no problem. Pleadings exchanged. Pleadings exchanged.
Yes, ma'am. My lord, this is my affidavit in opposition.